May I please, Lordship, in item number 57, 58 to 59, my lord, in supplementary list, we have filed an additional affidavit, my lord, that can be called for, my lord. Obliged, my lord.
Lordship, two repetition for listing. One was listed on September and one is November last year, Lordship. Any date as per convenience, Lordship.
Obliged.
Like to mention item number 45, my lord. This is a motion I yet to issue notice, my lord. Motion please, my lord. The analogous case may be 45 may be listed for motion, my lord.
Okay, we'll be here before 1 o'clock at 12:45.
Analogous case.
Be here at 12:45.
May I please, I beg to mention for listing, my lord, contempt case, my lord. It was last posted on 8/2, my lord.
Okay, on Wednesday, Monday next, 28/20.
Obliged.
May it please the Lordship, I beg to mention item number 23. My senior is out of station. We have taken consent from Guwahati University and the private respondent. May the matter be adjourned for the day, Your Lordship. Much appreciated.
May I please, Lordship, I beg to mention item number 28 and 29, Lordship. We have consulted the other side, Lordship. Please the matter adjourn for 1 week. Adjourn for 1 week.
May I please, your Lordship. Lordship, I beg to mention an item, Lordship, call for record in an item, Lordship, 57 to 66, Lordship. It's a part heard matter, Lordship.
We'll take it up at 2 o'clock.
2 o'clock, Lordship. We have filed an additional affidavit today, Lordship. That may be called for, Lordship. Much obliged.
May I please, Your Lordship? Your Lordship, I'm praying for listing for a writ petition. Matter pertains to provincialization of schools. The matter may
It's a new petition and so old pending matter.
old petition. It may come up for orders, Your Lordship. Anyway, any day this week.
16th.
Obliged.
May I please, your Lordship, I beg to pray before listing these two matters. As the matter is pending, it is last 2021, Lordship.
Okay, we'll have it on 22nd.
Highly obliged, Lordship.
22nd.
My lord, I beg to mention for listing contempt case. Last date of listing 22/2023.
Okay, we'll have it on 21st.
Yes, ma'am.
May please, Your Lordship, I beg to mention item number 55 of very list, Lordship. We have taken the steps by registered post, but neither AD card nor answered notice has been returned
Let
back.
us let the matter reach.
So, Your Lordship, may list the matter before the Lodgima Court, Lordship, for steps.
We pass necessary order. Okay.
Reach Kora, please.
Yes.
My lord, this matter may come up for orders on Friday, my lord. 2018 matter.
Not on
dismissal-
this Friday. Not on this Friday. We can have it on Monday,
Yes, ma'am.
28/20.
May please, Your Lordship. Lordship, I beg to mention item number 17, Lordship. Matter will be passed over for the day, Lordship. We have got a petitioner. 17.
On the prayer.
Obliged.
Yes.
May I please, Your Lordship, I beg to mention item number 21 and 22. Kindly pass over the matter for the day.
Mandal, anything?
May I please? My lord, one matter regarding
That
J&B.
thing, in fact, we are supposed to be listed today. It will come. I think 2 days it will be listed.
Yes,
That
ma'am.
matter.
And my lord, another matter, my lord, regarding my lord electrocution day, your lordship was pleased to fix the matter.
Just give the number.
Yes, I'll give the number.
Okay.
One review. My lord, one
Just
review.
review. Why it's not listing, I don't know.
Several
Review,
times, Lordship, we have mentioned it.
Review not in this week, next week. It's almost like just little thing is left out. We'll have it next week.
My lord,
This week it will some
on
problem.
Monday, Lordship.
Not on Monday because
Next
this court will maybe on Wednesday. Otherwise, we have to go to Shillong on Friday. For some-
That like we have mentioned it several times,
True.
Lordship.
We'll see it on Wednesday. Give the date next Wednesday. You come. That's it.
Yes, Lordship, the petitioner has already been appointed in some other department.
So she don't want Mr. Abdul Mazumdar and the council appearing for the petitioner and Mr. as the standing counsel our education for the respondent numbers 1 and 2. On instruction, Mr. Mazumdar, counsel for the Mr. Leonard counsel submitted the petitioner got appointment in some other department as such, not pressing this petition. Accordingly, to which counsel for the respondent have no objection. Dismissed not pressed. The interim order passed earlier on 27/10/2022 was accordingly cited. Mr. Das, now it will be your duty to inform the concerned department and the concerned college that this writ petition has dismissed on withdrawal.
One interim order.
That's what you have to inform.
Here, Lordship, I have received, we have compared with the order, Lordship. The petitioner's claim has been rejected because the.
See, Mr. Das, don't go ahead. That's the reason we inform Mr. Mazumdar, Mr. Sisti and others.
Yes.
To have that ape in the government. Immediately you could have informed it.
Yes.
That this is the order, petitioner has not placed this petition dismissed. That post could have been filled up now,
Yes.
right?
Yes.
Now, how much time it will take, we don't know.
The withdrawal part.
That's
That
right.
I will in my.
That is the reason
have a-
why you should have a particular app. so
We have
that
a
you
group,
can-
Lordship. I will immediately, that is, I will upload it, Lordship.
So
right
these
now.
are the things which you need to inform.
Yes, yes, Lordship.
And that you can do it through that particular
Yes,
app.
yes,
We've been doing so many apps, our officers are doing it.
yes, yes.
Hardly it will take time for you.
Yes. Take to upload it in the group.
These are the reasons we wanted you to do this anyway. Yes, Mr. Sisti.
Yes, Lordship, here, Lordship, only thing is that a speaking order has to be issued, otherwise they have informed us that their case has been rejected. But that speaking order they have to issue, Lordship. I have asked them to issue that order, Lordship.
Let them issue that order, otherwise first it will.
Yes,
Okay.
yes, yes.
Uh,
Within a week, Lordship, it will be issued.
The
Mr.
last
Sisti, Leonard counsel appearing for the respondent department submitted. The respondent authorities pursuant to the order
The director has already informed the secretary, Lordship, that
dated 30/07/2022 passed in WPC number 4859/2022. Shall issue the necessary speaking order at the earliest.
yes, Lordship.
Okay. List on 4th of May.
Yes.
The similar direction was issued.
Place an instruction, Malad. It is under consideration for compliance, Malad.
Sorry.
Compliance or compliance.
Get a definition.
Matter pertains to non-compliance of the order dated 25/07/2022 passed in WPC number 4728/2022. Pursuant to the order dated 20/02/2023. Mr. Sisti, standing counsel, Mr. Vikas, Vikas, standing counsel, Department of School Education, placed before the court that the Director of Elementary Education, Assam, after collecting the verification report from the Sarva Shiksha Vision, Assam, submitted the matter before, submitted the report before the concerned department, the state government, for necessary order. To that extent, Mr. Sachin has placed communication dated, communication number
Report is negative.
E-251065/19 dated 10/03/23. Issued by the Joint Secretary Government of Assam Elementary Education Department. List same day. May. So, correct.
Item 4, Malad, I am awaiting instruction. Malad will give me 2 weeks time, Malad. I've already.
On the prayer of Mr. Sachin Sach, place this matter on 21st of April to place
Obligation.
necessary compliance order.
May please, Your Lordship. Lordship, this matter pertains to completion appointment. The petitioner, father of the petitioner died on the 2015 Lordship, 9/1/2015 Lordship. Accordingly, after demise of his father Lordship, he applied for a completion appointment Lordship on the 17/3/2015. His case has been rejected by two DLC Lordship. First one is Lordship at 22/2016 Lordship. On the ground that ground of the time bar Lordship. Lordship will find it at page 16C Lordship. That is Lordship.
What is your name?
Lordship, Lordship will find it at page 16C Lordship. Type copy Lordship. Like for Jyoti Nath, son of like Kulodar Nath Lordship. Herein the date of her father has been recorded as 10/9/2005 Lordship, but it is incorrect Lordship. It died on 15 Lordship, 9/1/2015.
9/1/2015 only.
Lordship, but here in this Lordship by DLC, incorrectly observed that his father division died on 10/9/2005 Lordship. Accordingly, his case is rejected.
Where?
Lordship,
Page 16, it is 9th of January 2015. You're
that
reading
is,
where?
that is Lordship, date of application Lordship. Twenty-one 2015. It is Lordship the date of application Lordship as per the record Lordship.
Now what happened after this? It could not be considered due to want of vacancy, right? Then what happened?
Thereafter Lordship. There that is on the 16/9/2016 and due to the want of the vacancy Lordship. Thereafter Lordship again the Lordship the pension authority placed a case of the petitioner Lordship, that is Lordship will find it at page 25 Lordship on 8/9/2022 Lordship. Now it is to remain unattended Lordship.
Now this is the DLC.
Lordship.
This DLC when?
That's not decided Lordship. Second DLC was Lordship 16/9/2016 Lordship due to the want of vacancy Lordship.
26/9/2016.
16/9/2016.
16E.
That DLC Lordship will find at page Lordship 16F Lordship. Type copy Lordship. And 16G is the original copy Lordship.
This is an incomplete DLC Lordship. Only one page is given Lordship.
It is the furnished by the authority Lordship. In the reply of the RT application Lordship.
Probably because these persons have approached the Honorable High Court. And accordingly, since there's an order from the High Court, their cases have been considered and left out the other matters.
Yes, Lordship.
That's how, that is not the duty of the DLC. DLC has to take up everything.
Yes, Lordship.
There will not find any such order that whenever a writ petitioner seeking compassionate appointment comes before the court, only for him it will ask to consider. You have to consider for all on the basis of the decisions.
On merit Lordship, yes.
It is specified in the Uchitranjan Das, Fajarin Desa, everywhere. But Mr. B. Busher,
BK Gogoi.
sorry, BK Gogoi, counsel appearing for the petitioner. and Mr. Smdc, Standing Council, Department of School, Secondary Education,
One,
correspondent
two,
numbers
and
1,
four.
2, and 4. Also had MS Das from Government Education for the number 3. Other of the petitioner was a grade 4 employee of Jungal Bolohu God Shahid Smriti High School in the district of Nagaon, a provincialized secondary school of the state, who died in harness on 09/01/2015. Petitioner applied for his compassionate appointment under a die in harness scheme of the state for grade 4 post in the district of Nagaon under the Inspector of Schools, Nagaon, or any other equivalent department. On 20/02/2016, though the case of the petitioner was placed before the district level committee for compassionate appointment, district Nagaon, but where is time bird? You have seen? Where you are reading time bird?
Lordship, that is at this 16th C, Lordship, nice copy, Lordship.
Okay.
Here it is recorded as the date of death as the 10/9/2015. That is why, Lordship, there's say it time bar.
16 D is the relevant DLC. Last,
On 20, case of the petitioner was placed before the I think it's wrong somewhere.
Set observations are wrong, Lordship.
Please come to page number 16B.
yes, Lordship.
D,
B.
Lordship. Lordship, yes, sir. Which refers to the subject cited above, I have the honor to submit here which a minutes of DLC meeting held on 20/02/2016 in connection with the compassionate ground appointment comparing various heads of officers of the district for favor of a kind perusal and necessary action.
Something wrong then. Why again on 26th of September your case was considered?
Lordship, that observation was Lordship incorrect, Lordship. That observation was incorrect, Lordship, because Lordship his fighter died on the 15th, Lordship.
Mr. Gogoi. Then why again your case was considered on 26th?
It is the department, Lordship. It is the authority, Lordship. Being the released a mistake, Lordship, maybe, Lordship. They again they place it on the next DLC, Lordship.
I think due to
On
wrong noting of date of death, Lordship.
26/09/2016. The DLC Nagaon would not consider the case of the petitioner to want out against it. As the respondent authorities did not inform the petitioner whether his case for compassionate appointment was taken thereafter or not, whether the DLC of the case of the petitioner for compassionate appointment or not, he has approached this court in this petition. If or not application, and if so, what is the result? What is the outcome about it? And as such, it is to be noted here that the case of the petitioner was earlier considered on 20/02/2016 by the DLC Nagaon. On which the hand his case was rejected. His case for compassionate appointment was rejected, considering his application as time barred as it wrongly came to the conclusion that the date of father of the petitioner was 10/9/2005, and they filed application on 21/03/2015. List on 10th of April or 11th of April, enabling the response number 3 as well as the response number 4, Deputy Commissioner Nagaon as an Inspector of Schools Nagaon, to apprise the court about the status of application of the petitioner for his compulsory appointment. Petitioner sells out by tomorrow.
May I please the Lordship? Lordship, matter pertains to compulsory appointment, my lord. My father died in harness, my lord, in the year August 2007, my lord. After 4 months, I have made the application, my lord. My grievance is that, my lord, my name has never been placed before the any DLC, my lord. I have time to time approached the authority, my lord. And my prayer is also limited, my lord, to direct the authority for next available petition.
Mr. Smdc. And the council successors for the respondent number one. Data's room, government application for the respondent. When your mother received pension?
My lord, I have not mentioned, my lord, regarding the pension issues, my lord. I have made the application on 21, page 14, my lord. After 4 months, my lord.
Where is any died harness? This is any airship certificate?
Regular service.
Regular certificate.
No, my lord, I have made the statement and paragraph number, my lord. Oh, my lord. Hello,
Where you have stated that this is a provincialized high school, Jawaharlal Nehru High School.
my lord, appointment letter. Yes, my lord, appointment letter, I have not annexed, my lord.
That is the reason.
My lord.
Unless you can establish that your father was a government employee, you will not be entitled for any such compulsory appointment. Where is that to show? Petitioner is allowed to file additional affidavit.
Regarding, my lord, my
To
father's
establish the fact that his late father, Interjul Jamir, was a government employee at the time of the administration.
Yes, that's his name.
Obliged,
Yeah, I'm only maybe reflected in the publication.
Registrar leaves this matter for motion only after filing such additional affidavit by the petitioner.
Okay,
Obliged, my lord.
Registrar shall reflect the name of J. Hassan the columnist for the response number 4 against this item. Yes.
Well, obliged.
Lordship, this matter may be passed over for time being.
Yes, Mr.
My lord, hearing this case, my lord, earlier we approached, my lord, for dropping of their name from the provincialization. My lord, that pair, my lord, the direction was not considered by the impugned order, and that we have challenged, my lord. Impugned order, lord, you will find it 60, my lord.
See your prayer.
My lord, the order of this, earlier order of this.
No. Your prayer
Yes,
made
ma'am.
in disposition page
My
21.
lord. It in the nature of mandamus surgery shall not be issued, setting aside, page 21, my lord.
Hmm.
Setting aside and quashing the impugned speaking order debtors for rejecting their claims of provincialization of services in their respective school, giving due consideration to their past long services, age factor, and the law and force at the time of their appointment, so far relates to the educational qualification, giving relaxation to strict rule of present law in force, so far relates to qualification, and or alternatively, they may be granted time to acquire the requisite qualification until then necessary arrangement shall be made to pay their
See,
remuneration.
difficulty, as you know, is that their prayer may be same, but they are from different high schools.
Yes.
Their working period is different. How we can make in one repetition?
And the cause of action is same.
But that doesn't matter. But the authorities, while passing such kind of order, I know what is the difficulty for the authorities. You don't realize. Then why do you file separate writ appeals when the court passes a common judgment? Issue is common. Then why do you file separate writ petitions or writ appeals? Tell us. Why do you file separate writ appeals?
I will be given some time to.
You should. You withdraw it and file separate writ petitions, we will consider. The instruction of the petitioners, Mr. Secretary Council appearing for them. Raise for this petition. With a liberty to file fresh writ petitions again for each of the petitions. Prayer allowed, liberty assistance and dismiss on the. Please look. Yes, Mr. Malada.
This is regarding my proportionate appointment. Now, Lordship kindly see page 26. The proposal my lord, submitted by the block limit education officer has not been my lord, placed before the DLC. Page 26, Lordship kindly see.
Just.
His father my lord, died on 31/10/2011. He applied on my lord 16/4/2012.
In this case, also, I have to take instruction, Lordship. Since
Just a-
2011,
just-
now they have approached Lordship.
When did you apply?
My lord, applied on my lord 16/4/2012.
Where is it?
That your lordship will find at is my lord 20.
Your application declaration, no date, nothing.
Yes, my lord, yes.
Where from you are saying 20? Where from you are saying?
It is reflected in the my lord proposal itself, my lord.
But Mr. M. Mandal counsel appearing for the petition. MS. Just Roman government advocate Assam for the response number 1
And 5.
and 5. Also heard Mr. Zipripo.
Response number 2 and 3.
Standing counsel for education for the response number 2 and 3. Mr. A. Saliha, standing counsel finance for the response number 4. Father of the petitioner. Moklisur Rahman. An assistant teacher of Ghan BAGH, ME Madrasa. Uttarakhand Education Block of District Karimganj. Died in harness on 31/10/2011. It is submitted. The Dodi petitioner submitted his application for his professional appointment in grade 4 course after the death of his father within the stipulated time. That was forwarded by the Block Elementary Education Uttarakhand on 16/4/2012. Till that this case has not been placed before the district level committee for compassionate appointment Karimganj. Hence district petition. List on 26th of April. And the said date. The district elementary education officer of a party. Why have not made DUA party? He is the secretary. You will only place it before the deputy commissioner. Lika. For proper education of districts, the district elementary education officer. Karimganj. Be implemented as a part of, secretary. The district level committee for completion and appointment. Completion appointment in the education department of Karimganj district. Be implemented as part of one number 6. Mr. Prabhu, standing counsel and the reference on newly implemented as one number 6. Based on such and such. The response number 5. Chairman of the district level committee for completion and appointment. District Karimganj as well as the secretary. Response number 6. DEO come secretary party. I go to chairman come deputy commissioner. Place the 11 instructions in the method. Whether the case of the petitioner was placed before the DLC for infants. Or not. And if so, what is the outcome of this?
Pendency may not be bar.
Pendency shall not be about for respondent authorities to consider the case of the petitioner for its compassionate appointment by the district level committee for compassionate appointment, Karimganj district.
Developers.
Yes, Mr. Declan. So with limited prayer lordship, the petitioner is before your lordship. The grievance of the petitioner is that lordship, the respondent authority, without preparation of the seniority list and determining of the seniority, they allow the non-qualified candidate, that is respondent number 5, he is non-B.Ed candidate. He is allowed to hold the charge of the school with effect from May 2022. So after completion of B.Ed degree lordship, I file application before the authority and to make security graduation list. But till that, they have not done anything, lordship. That is why I am before your lordship. So, lordship, my limited prayer is that let a direction be given to the authority to prepare the seniority list. And on the senior basis of the seniority list, the eligible candidate may be allowed to hold the charge. That is my limited prayer, lordship. In the school, initially he was appointed by the managing committee. Thereafter, school provincialized on 15/8/1994. And date of effect of receiving graduate scale of pay of both the petitioner as well as respondent number 5 is 15/8/1994. Now, by invoking the rule 24(7), if the date of joining of the cadre is same lordship, then date of birth is accountable for determining seniority. So, by taking result of this provision of rule 24(7), also I am eligible for the post, and I am the only B.Ed candidate in the school lordship. So, in 2020, lordship, I was allowed to deputed to undergo B.Ed training. Then I completed this training. Then I released from the order. So thereafter, I prefer an application before the authority to allow me to hold this charge. But it is still pending, lordship. But the facts remain, lordship. They have not prepared the seniority list, and as a result, I also could not annex that seniority list.
Where it was updated?
On 15/8/1994, I have made a statement, lordship, paragraph 2. Madrasa, thereafter the service, paragraph 2, page 5. Thereafter the service of, in middle portion, lordship, thereafter the services of teaching, non-teaching staff of the madrasa, including the service of the petitioner, have been provincialized by the government with effect from 15/8/1994 under the Provincialization Act of 1995. Now, earlier, lordship, the name of the school is Solmare Senior Madrasa. Now, with effect from 2020-21, now it is known as, lordship, Solmare High School, lordship. The earlier incumbent, he retired in the month of March 2022, that I have, lordship, stated in paragraph 5. And in the
Heard Mr. Redeka, counsel appearing for the petition. And Mr. P. Cost extending counsel, Department of School Education for the respondent numbers
1 to 4.
1 to 4.
On 10th of March, similarly, it is on a disposal by your lordship. Same factor. Only difference is that that school was amalgamated, but here the school is not amalgamated. The name of the madrasa itself, now it is known as Solmare High School. The difference is that the respondent number 5 is not having the B.Ed candidate. So, in view of the division bench order and
Due to superannuation of the erstwhile regular headmaster, after headmaster of Solmare High School, Nagaon, the director of higher education, Assam, but the director of the inspector of schools.
Director, lordship, I have stated in paragraph 5, lordship.
Allowed the respondent number 5
with effect from May 2022.
Allow the respondent to hold the charge to be the in-charge headmaster of said high school with effect from 1st May 2022. Though he doesn't have the requisite eligibility of B.Ed degree to hold a post of headmaster in the provincialized secondary schools of the state as provided in the 2018 rules of writing.
Rule 14(2).
Petitioner submitted. Said Solmari High School, Nagaon, Solmari High School. Just a minute. Lawgaon, Lawgaon, comma Solmari, in the district of Nagaon. Was earlier Solmari Senior Madrasa. And was a government aided senior madrasa. With effect from 15/08/1994, the services of the teaching and non-teaching staff of the said senior madrasa was provincialized, including that of the petitioner as well as the respondent number 5. And since then, the said madrasa came to be known as Solmari High School, provincialized under the Assam Madrasa Education Provincialization Act 1995. Both the petitioner and the respondent number 5 drawing graduate scale of pay from the date of provincialization their service I 15/8/1994. Since there is no such B.Ed qualified teacher in say Solmari High School, the DHC Assam, the DSC Assam allowed the respondent number 5, senior most assistant teacher of the school, to hold the charge of headmaster of said school due to superannuation of the erstwhile headmaster of that school.
At page 10, paragraph 8, I have stated the reason.
In the meanwhile, there was a senior most military holding him to be senior above the petition, considering him to be. And in the meanwhile, the Director of Secondary Education Assam, by an order dated 2010-2020, deputed the petitioner for his B.Ed degree and accordingly by order dated 2010-2020 and placed him at Shikshan Mahavidyalaya Nagaon for such training for a period of 2 years for the session 2020-2022. On completion of his B.Ed training, when did you pass
On 1st of September 2022, serial number 21, page 25. Release
No, that-
order from
Release
DC.
order, but when did you pass?
Yes. 10th of Lordship result mark sheet dated 10th of December 2022. Lordship, this is a copy of the mark sheet. 17th result declared on 10th of December. The certificate issued on 17th of December.
Petitioner submitted that he passed the B.Ed degree from SID Section Mahavidyalaya conducted by the Guwahati University, June 2022, result of which was declared on 10/12/2022. In first class. After obtaining his B.Ed degree, the petitioner on 08/02/2023 submitted a representation before the Inspector of Schools, Nagaon District Circle, Nagaon, respondent number 4, to allow him to hold the charge of headmaster of the same such and such school, as he has all the eligibility for promotion to the post of headmaster high school as provided in 2018 rules. An essay representation dated 08/02/2023, petitioner submitted that the respondent number 5, who is holding the charge of headmaster of the same school, is not qualified to be the regular headmaster of any such provincialized secondary school in terms of the 2017. Placing the reliance report in advance of this court in the case of such and such, reported in such and such. That's a data submission. Only an eligible candidate for a particular post should be allowed to hold the charge of the same post. But in the case in hand, the petitioner is eligible to hold the post of headmaster, having B.Ed degree and the length of service in a graduate scale of 3. But the respondent is still allowed, the respondent number 5, the excess headmaster of such a school doesn't have the to be a headmaster of any provincialized secondary school of the state.
This is regarding the data field reported in 2016 5 GLT 52 and Jagannath Peku is 2007 3 GLT page 389. 2007 3 GLT page 389. Jagannath Peku.
The petitioner, Mr. Dekar, has also placed a reliance on the order, the regular 07/06/2016, passed by Honorable Division Bench of this court, reported in 2016 5 GLT census. Anwar Firoz Mehdi versus State of Assam in that paper. Petition is directed to submit this representation for the Director of Secondary Education, Assam, to the Inspector of Schools, Nagaon, on or before 30. All the qualifications along with the testimonials in that regard. The event of filing such and such. Director of Secondary Education, Assam, within a period of 30 days from the date of receipt of such representation. Say representation. Dispose to the case found eligible to hold the post of such and such. If the same respondent number 5 doesn't have the legal right, shall be done in accordance after hearing the petition.
Also make an observation to prepare the seniority list, but till that I know that the seniority list is not prepared. Because not to take a decision of
It is also made clear.
the rule 25.
The
Rule
Inspector of Schools.
Rule 25 of 2018 rule. District of seniority. I have rule 20. I have quoted at page 10 paragraph 8. Rule 25 as well as rule 24(7). While the date of joining of a cadre or teacher of a cadre is same, then they should invoke the rule 27 clause 7. And according to rule 25, they have to determine the seniority. So by invoking the rule 25 and 27(7), I am also eligible. That may make an observation.
Just
Rule 25. Rule 27. 27. Date of joining to actually date of birth. Date of birth. 27 sub rule 7. This is regarding while determining the seniority if they found that the date of joining in the post is same.
2018 rules.
18 rules.
You are saying 27. 27 is probation and confirmation.
24/7. 24. Sorry, 24/7. Sorry, madam, I'm wrongly put it. Yes, rule 24/7. If the date of joining in the school is same, because they have provincialized with same date 15/8/1994, between two or more member of service in a cadre is graduate teacher, the inter-se seniority shall be determined taking into account the date of birth.
The Inspector of Schools, such and such. What a direction. No, to prepare the gradation list. Contained in the such and such. Following the provisions of Rule 24 of the same 2018 rules, including Rule 24 in bracket 7. 24 prepare the gradation list about the teachers and teaching and non-teaching staff. As provided in Rule 25, following the provisions of Rule 24, 2018 rules, including Rule 24 in bracket 7, which provides that. Yes, Mr. Gogoi.
This case is that he was suspended in the year 2012. After that, he was reinstated. But he is the service was not regularized and the Department of Proceeding not yet completed. Also, his increment has been withheld from 2012. For his petitioner approached the authority that no action has been taken.
Where is the appeal before the
This is at page 30. Next 7 হচ্ছে পুরা ডাইরেক্টর আছে for regulation of service during suspension period and release of unassigned areas of suspension period and release areas annual salary loss. It should be increment loss.
What is your order of suspension?
Suspension order is loss at page 15. Page loss. Yes, okay, 15. Page 15 loss the suspension order.
Where is the order of
Order of
reinstatement?
reinstate is loss at page 21. Next at here. Order dated 2nd March 2013 loss. Pending financial department proceeding, so junior assistant officer of the district limited education officer in Durham was placed under suspension by this office order dated so is hereby reinstated in service and posted in his original place of posting with immediate effect loss. After that loss, he joined in his posting and he applied for file application for regulation of service loss. That is at page 24, which was forwarded by the DO to the director loss. In the year 2020 loss. Page 24 and extra 5. Again, he approached before the district and limited education officer on 10/6/2020 loss. Page 26. The district limited education forwarded the application to the director on 8 June 2020 loss. Page 27 is the forwarding from the district limited education officer to the director loss.
You are serving as what?
As junior assistant.
But Mr. N. Gogol counsel appearing for the petition. You are still using the postal stamps.
What's it?
You are using these stamps. You are not filing, you are not making e-filing, e-stamping. These are easier process.
I will do it next time.
Should go for it. It's an easier process.
What's it?
Petitioner is junior assistant in the office of the district elementary education officer Durham. Was placed under suspension by the director of elementary education Assam by the order 0406/2012. Later, a little bit. By order dated 02/03/2013. The director of elementary education Assam reinstated him in service and posted him in original place of posting with immediate effect. do in between by order of 2013 of the order issued by the DE Assam. He was transferred and posted in the office of the DIF school Nalbari in the same capacity. But by another order dated 18/11/2013, DE Assam again transferred him from the office of the DIF school Nalbari to the office of the Block Elementary Education Officer Dalgaon in the same capacity where he is presently serving as a junior assistant. Though petitioner submitted several representations before the district director of elementary education Assam to regularize his suspension period from 04/06/2012 to 02/03/2013 and to pay him allowances, substances allowances, unpaid substance allowances for the same period. But till date, his representation have not been considered. The petitioner for the state that though the state government in the elementary education department on 21/01/2022 sanctioned an amount of ₹1325 for payment of his arrears salary. That has been paid or not?
Yes, that was paid for 1 day. That is amount will be 1325. I have received that amount.
Definitely.
Annual income also returned from 12
Since the petitioner's suspension period has not yet been regularized, he is not getting the benefit of annual increment. The petitioner is directed to submit a fresh representation before the Director of Elementary Education Assam on or before 30/03/2023 through the Block Elementary Education Officer Dalgaon and the District Elementary Education Officer Dorong Mongolrui with a certified copy of this order stating his grievances regarding non-regularization of the suspension period from such and such and unpaid subsistence allowance during the same period. The said representation petitioner may also submit his grievances regarding non-payment of annual increment to him after re-entering his service by the order dated such and such. In the event of filing such and such within the said period, the Director of State Elementary Education Assam shall dispose of the representation of the petitioner 31st of May. I find the records. Speaking order. But necessary order of regularization suspension period and payment of suspensions in the lands benefit of annual increment as per his entitlement in accordance. Any of this.
The petitioner pays for considering a prayer for promotion because he's working in the same post since last 9 years, retiring in the month of July 23. Lordship candidate pays 19 months. He was appointed as a research officer under non-formal education state resource center.
Did not get the benefit of SCP and MSCP.
No, that benefit is. To my knowledge, she is working as assistant director.
No, that financial benefit was not given to you.
No, I don't.
That I love to take it, sir. Because
Is this matter on 28th, on 21st, enabling the Director of Non-Formal and Adult Education, response number 3, to apprise the court as to whether the petitioner granted any such financial benefit as it is stated that since January 1992, since January 2014, the petitioner is serving as
assistant director, February
Assist-
2015.
with effect from February 2015, she is serving as an assistant director in the State Resource Center, Guwahati, under the Directorate of Non-Formal Adult Education, without any promotion. And that she will be retiring from service on 30/07/2020. Copy of this order to Mr. B. Kaushik, such and such. Petitioner shall serve an extra copy of this petition to Mr. Kaushik by today itself.
It will come up on
21st.
21st.
No representation on repetition. Please substitute.
Please, your option in item 67, the senior counsel is on legs.
68.
67.
67 to Gole.
May kindly pass over the matter for the time being, Your Lordship.
Similar prayer, my lord, my senior Mr. Ambassador is appearing, my lord. For the time.
What is the, what is it?
It is same, those person they are challenging that advertisement of 28/12/22. Last date was already over by 28 February, Lordships. They were not yet qualified. As you will appear in this case also. Lordship.
My senior will be asking for an interim order, my lord. That's why I'm
How
praying
can be possible? Personally law.
for the timing. This
Even last date was already over on 28/2. They've come after the last date Lordships.
after some time. Matter will be over.
When is the last date of submission?
It was already about 28 to 23 Lordships.
So,
Now my senior friend has come, Lordship. May kindly let the Advocate General come. Yes. Iya teman. Yes,
Procedural. My lord, this requisition has been filed by 101, my lord, my lord, prospective candidates. And their particulars are given in, my lord, Annexer 1. When they have passed and when they have obtained a degree, they are all, my lord, either graduate with B.Ed or postgraduate with B.Ed degrees. And they have passed after the last selection was made for the recruitment of teachers, postgraduate teachers and graduate teachers. Now they are aggrieved by the advertisement dated 28/12/2022, while 4 advertisements have been issued. 2 for graduate teachers of provincialized high schools as well as government high schools, and 2 for postgraduate teachers in provincial schools and government higher secondary schools. Now, my lord, their primary grievance is that the last selection was held, my lord, advertisement issued in 2019. Although, my lord, 4,000 posts were advertised, more than 11,000 appointments have been made. And now they are not eligible to appear in the present advertisement because there has not been any TET examination for the last 3 years. So far as graduates are concerned, and my lord, so far as postgraduates are concerned, it has not been held in 2021 and 2022. As a result, they are not eligible to be appointed. My lord, may I please a small note, my lord, which will help your lordship in understanding the, my lord, brief. Now, these advertisements were issued on 28/12/2022. Those are at page 62, 66, 72, and 79. And in these advertisements, no last date was, my lord, given. Only the number of posts were given. The total number of posts that are given, my lord, for postgraduate teachers in provincial schools, 1,385, and government secondary schools, 118. Graduate teachers, 7,500. And in provincialized, and graduate teachers in government secondary schools, 255. Now, their grievance is that the persons who will now apply and who has the eligibility, they had the opportunity of appearing in the earlier selection, and they are much less in number than the post advertised. If your lordship, my lord, takes up my note, your lordship will find in the 3rd page, my lord, there are graduate teachers, my lord, 7,776 posts, and postgraduate teachers, my lord, 1,503 posts. Those are advertised. Against that, my lord, total number of actual candidates for postgraduate teachers, my lord, because the last date is already over and they have applied, 1,099. And so far as graduate teachers are concerned, my lord, although there are 7,776 posts, only, my lord, 2,242 have applied. And these persons, my lord, got the opportunity in the earlier selection advertisement that was held in 2019. Now, their grievance is that since the authorities are required to hold the TET every year, and since it has not been held for graduate, my lord, postgraduate teachers and graduate teachers for the last 2 and 3 years, they have not been able to obtain the eligibility condition. And their, my lord, the grievance is fortified by an order of this honorable court earlier, which says, because, my lord, in 2019 also the advertisements were issued, and my lord, some prospective candidates came, and this honorable court directed that you hold the TET first, then you make the recruitment. If I may draw your lordship's attention to that order, your lordship will find it is at, my lord, page, it starts at page 86.
sorry, my lord, 91 in the writ petition. That is a judgment by a concurrent bench of this honorable court, and relying on a division bench order, your lordship may straight away come to page 111. Page 111, paragraph 11. May I read it, my lord?
Yes, yes.
Accordingly, considering the submissions advanced by the learned counsel for the parties and the decision rendered by the division bench of this court in writ appeal 32 of 2019 on 28/3/2019, and for the reasons discussed above, this court is of the opinion that the present petition can be disposed of with a similar direction. Accordingly, this petition is disposed of with the following direction. The state government will immediately take steps for holding TET examination so that the petitioners or such other candidates who may be desirous of obtaining TET qualification may appear in the same. It is only after TET examination is held and the results thereof are declared that the state authorities can proceed with the recruitment process for appointment to the post of graduate and postgraduate teachers in high schools and higher secondary schools in terms of the advertisement challenged in the writ petition. There, my lord, that advertisement was challenged, by which, my lord, they wanted to make a recruitment in the and any other advertisement issued for appointment to the post of graduate and postgraduate teachers in high schools and higher secondary schools. This court, this is also relevant, my lord. This court would also like to observe that though the petitioners had initially submitted for allowing them to take part in the recruitment process without insisting upon the TET qualification, and that their selection may be subject to subsequent process of TET exam qualification, to which this court would have agreed. However, in view of the decision rendered by the division bench of this court under similar circumstances as referred to above, instead of allowing the petitioner to take part in the recruitment process subject to the qualifying in the TET examination, they shall be allowed to appear in the TET examination, and only after they are found successful in the TET examination to be held as directed above, the recruitment process will be initiated. Accordingly, it is declared that till then, the recruitment process initiated by the impugn advertisement dated 14/8/2019 and any other advertisement for appointment to the post of graduate teacher and postgraduate teacher in the high schools and higher secondary schools shall be kept in abeyance. So, my lord, in compliance with this order, my lord, the recruitment process which was initiated on 14/8/2019, that has been, my lord, that was suspended. Then the TET examination was held, and thereafter those candidates who appeared in the TET and qualified, they got the opportunity of participating, and the selections have been made and appointments have been made. In fact, my lord, although 4,000 and all these posts were advertised, in the meantime, my lord, more than 11,000 teachers have been appointed. We have no grievance regarding that. Now the grievance is that, and this decision was rendered relying on a, my lord, division bench decision. So there, my lord, contention is that the number of post teachers, candidates who have now appeared, they are much less in number than the required number of vacancies, and they had already an opportunity of applying in the earlier test, earlier selection process. These posts, which now they are advertising for filling up, those are vacancies arising after the recruitment process of the 2019 advertisement was completed. And therefore, there is no reason why this order should not be complied with. Then these, my lord, in fact, my information is that there will be around 40,000 candidates who will be interested in appearing for the TET. They should get an opportunity of appearing in the TET, and thereafter, otherwise they are qualified, except the TET examination because of it was not held. And now, my lord, after filing of the writ petition, my lord, I had come across two newspaper reports, my lord. One has reported that against 7,500 posts, only 2137 candidates appeared. And these 2137 candidates are those, my lord, who could not be successful in the earlier selection process. And my lord, to add insult to injury, my lord, on 10th of March, another, my lord, news item has been published which says that the Honorable Minister of Education has said that for the next 2 years, they will not be holding any TET examination. And one aspect of that, my lord, news item, I'll my lord put it on record because this has come after filing of the writ petition. There, my lord, the minister has said, আনহাতে মাধ্যমিক পর্যায়ের বাবে আমি বিকল্প ব্যবস্থার কথা ভাবি আছি। That means they may do away with the requirement of TET. If they may not do away with this requirement, then these persons who have in the meantime qualified after the last advertisement, after the completion of the last selection process, they should be allowed to participate in the proceedings. Now, against 7,500 posts, that is what is reported, only 2137 candidates are available. And my lord, in these days of unemployment, my lord, all these petitioners, they are B.Ed qualified. They have more than 50% marks. They, my lord, fulfill otherwise all the eligibilities. Therefore, my lord, my prayer is that your lordship will direct the, in terms of the earlier direction of this honorable court, direct that they should hold the TET first and thereafter complete the recruitment process, so that, my lord, the new young blood, my lord, they can also participate in these hard days of employment, my lord. They are looking for, and this is the only opportunity they have. And my lord, there must be some reason we do not. I fail to understand, my lord, the persons who have now applied, they have earlier failed in the earlier selection process. What is the, my lord, special, my lord, treatment they deserve to be given against, my lord, 7,500 posts, only 2,000 and odd, my lord, candidates are there. There should be a fair competition in public employment, and that opportunity has not been given. If your lordship, my lord, goes through the notes that I have prepared, my lord, the earlier advertisement was issued on 14/8/2019. Then this honorable court stepped in and said that you hold the TET first. That judgment was on 29/8/2019. So they kept in hold the selection process, and thereafter, after holding the TET examination, they had completed the selection process against, my lord, 4,722 posts of graduate teachers and 345 posts of postgraduate teachers. And in the meantime, my lord, they have appointed. There were more vacancies coming, and therefore more than 11,000 persons have since been appointed. And these, my lord, persons who have now applied, that limited number of 2,137, my lord, they could not get a berth in, my lord, those 11,000 posts. And they are sought to be recruited. There will be no competition. Everyone will get it at the cost of the, my lord, education system of this country, my lord. They'll be serving for the next, my lord, 30 years, and that too without competition. Therefore, my lord, following the judgment that has been passed by this honorable court earlier, the prayer I make is that, my lord, that this should be kept on hold. They should be directed to hold the TET. And, my lord, the minister says that they were thinking of alternative. If they, my lord, take that alternative of, my lord, doing away with the TET, my lord, then also, my lord, these petitioners can participate in the selection. Let there be a fair competition in the, my lord, selection process. This is my submission.
Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. M. Bardwaj, Learned Counsel for the petitioners, and Mr. D. Saikia, Advocate General of the state, assisted by Mr. Smdc for the respondent numbers 1 and 3. The state government in the Directorate of Secondary Education Assam, state government, on 28/12/2022, issued 4 sets of advertisement by advertisement. Number GB-EST oblique advertisement within bracket GT and PGT and numerical bracket close oblique 1 oblique 2022 oblique 7. The DSC Assam invited applications for filling up of 1385 vacancies of postgraduate teachers in different provincialized secondary schools under the DSC Assam. In the scale of pay of rupees 22,000 to cash declare rupees 97,000, including grade pay of rupees 11,800 per month under the pay band 3 plus other allowances admissible under the rules. Next, if you by advertisement number GB-EST oblique same advertisement GTN PGT oblique 1 oblique 2022 oblique 8. They say the DSC invited applications for filling up of 118 vacancies of postgraduate teachers in the different government secondary schools under the DSC same pay scale. By advertisement number such and such, last to 9 they say invited applications for filling up of 7500 vacant post of graduate teachers within bracket arts, graduate teachers within bracket science, graduate teachers within bracket Hindi, and graduate teacher within bracket Sanskrit in different provincialized secondary schools under the DSC Assam in the scale of pay of rupees 14,000 dash to rupees 70,000, including grade pay of rupees 8,700 per month under the pay band 2, Roman 2. Please take your seat, Mr. Chaudhary.
My lord, only one thing I'd like to add, my lord. Although, my lord, that advertisement was issued on 28th of my lord, December, no last dates were given. That was, my lord, notified only on 14/2/2023. That I wanted to point out. That your lordship will find at page 86. They have given all the category was post in the website, and online application last date is 28/2/2023, and now they are going with the verification of the documents, and last date is up to 17th of March. So that is the stage of the my lord recruitment process.
27th of March.
17th of March, my lord, the notification giving this last date and application, my lord, that was issued page 86, 14/2/2023. On that day,
No,
this was a notice.
verification is up to?
Verification is up to 17th of March. It is going on now.
Advertisement dated same day. GBST last to 10 for filling up of 255 vacant post of graduate teachers arts, graduate teacher science, graduate teacher Hindi, and graduate teacher Sanskrit in different normal secondary schools. The scale of pay is same. For the post of postgraduate teachers, both in the provincialized higher secondary schools as well as government secondary schools. The requisite academic and professional qualification of a student by an incumbent candidate is that he/she must be a postgraduate in concerned subject with at least 50% marks or its equivalent from recognized university. Roman 1 to 2 should possess Bachelor of Education qualification from an institution recognized by National Council for Teachers Education, specifying that degrees obtained from off-campus and distance education institutions shall not be considered as valid. Truly clear. The applicant should have appeared and passed higher secondary teachers eligibility test in the concerned cadre conducted by the government, scoring a minimum of 60% marks in case of unreserved category of candidates and minimum of 55% marks in case of scheduled caste, scheduled tribes, other backward classes, and persons with disability candidates. Page number 62 to assess condition to the point of 62, 66. Similarly, for the post of graduate teachers both in provincialized and higher secondary government secondary schools of the state, the qualification, academic qualification. Petitioner submitted that the petitioners are either graduates or postgraduate degree holders with B.Ed degree, valid B.Ed degree. But it doesn't have the teachers ability test qualified certificates. Since after the last PET for graduate teachers,
For graduate teachers, it was held on 10th of January 21.
That's
And postgraduate teachers.
last held in January 2020.
For PGT, my lord, and January 21 for the graduate.
I think it's wrong. January, as per this graduation.
Yes.
Last in January 2020.
Yes, sir. Yes.
January 2020. No such state examinations conducted by the respondents in the secondary education
And
department.
they have acquired their
They have been
degree
their
after that.
graduation after January 2020. With regard to the petitioners having master degrees, be it submitted that the last teachers ability test for higher secondary teachers was held in January 2021. No, I think January 2021. And thereafter, the state government, the secondary education department did not conduct any such higher secondary till date one. And they obtained their master degrees would be after January 2020. Since the respondent authority did not conduct any such teachers eligibility test either for the graduate level or for the secondary education, they could not appear in such examination and obtain the relevant state qualifying certificates. As such, the petitioners, in terms of the judgment and order of this court passed earlier in WPC number 6168/2019, for case Kolita and 32 others versus State of Assam and others, decided on 29/08/2019 by another coordinated bench of this court, praised before submitted but prayed that the advertisement dated such and such. पूरा prayer kita All right, your page number 41 for us. Along with an interim prayer to suspend those advertisements dated 28/12/2022. Petitioner also placed before the court that the Director of Secondary Education Assam on 25/02/2023 on 14/02/2023 issued a notice specifying that the district-wise, subject-wise, medium-wise, and category-wise post details for the post of postgraduate teacher as well as graduate teachers of both government and provincialized secondary schools, for which advertisement was issued on such and such, shall be available in the official website such and such from 15/02/2023. And the provision of online application will appeal from 12 midnight of 16/02/2023, that will end on 12 midnight of 28/02/2023 in the official website of such and such. But the said notice that it 14/02/2023, the DSC Assam also clarified that physical verification of the documents / testimonials of the applicants for those posts advertised on 28th shall be done centrally in the office of the Directorate of Secondary Education Assam with effect from 04/03/2023. On instruction, Mr. Chaudhary submitted that such verification will come to an end on 17.
No, that's a document, my lord. That is at page 87.
Okay, and that. Such verification will come to an end on 17/03/2023. Communication dated 02/03/2023 of the DSC Assam. It is also placed before the court that the DSC Assam by an addendum dated 25/02/2023 gave the breakup of graduate teachers of Boro medium under Kamrup and Nalbari districts. Prayer portion. From the perusal of the order dated 29/08/2019, passed in WPC number 6168/2019. It is seen that the same was in consonance with the decision of the Honorable Division Bench in writ appeal number 32/2019, disposed of on 28/03/2019, regarding the filling up of the vacant post of graduate and postgraduate teachers in provincialized secondary schools of the state. In said WPC number 6168/2019, the advertisement was of 14/08/2019. And after considering and the respect in the court by order it such and such. Page 111 likha. At para 11. This was the following direction to the respondent authorities. In the case in hand, the petitioner, 101 petitioners have filed this petition on 10th March 2023.
We filed it on my lord 4th of March. There was
Lekha 03/03/2023. The signature of the departmental authority in the filing section on 04/03/2023. After the last date and time of filing of application for the post of graduate and postgraduate teachers in provincialized and government secondary schools of the state, advertised on 28th September 2022. From the records of WPC number 6168 2019 is seen that in that case, that in the said petition, the advertisement was of 14/08/2019. The court refresh কৰিব লাগিব। Refresh নকৰিলে নাহে নেকি? In its order dated 27/08/2019, recorded that it is seen that said WPC number 6168/2019 was filed by the petitioners therein on 26/08/2019. And the court, the order dated 27/08/2019 passed in CWPC recorded that the last date for submission of the applications in terms of the various advertisements issued on such and such had been extended up to 7th of September 2019. And thereafter, they passed the order dated 29/08/2019 has been annexed in this petition. But here, the last date of submission of application for those post advertised on 28/12/2022 is already over. And as such, even if we accept the statements of the petitioner and pass any such order, but in exercise of the powers conferred under Article 226 of the Constitution of India, the court will not able to extend the last date of submission of application to the petitioners, as it has already come to an end on 28th of February 2022. In view of the above, this petition, with the prayers of the petitioners made at A, B, C, D, A, B, D, and E stands rejected. However, the petitioners may approach the appropriate authority for submitting their grievances and for direction to hold the teachers eligible test for the postgraduate thesis and postgraduate thesis by the state authorities. Accordingly, this petition stands disposal. We cannot allow you to that extent.
My lord, only one prayer I make, my lord. I have relied on a newspaper report, my lord, that the honorable minister has said that it has they will not hold TET for the next 2 years. May I pray, my lord, this may be recorded, and that they are thinking of alternative arrangement for lessening the burden of the state.
Can you give us a copy of that? Yes, just give us a photo.
That's in the first at the first page, my lord. And the portions are is 8.
Only to that extent. Okay. We'll give this in our order.
That may be incorporated.
That correction is not good.
It is, here I have received one instruction, also I have given it to mail lordships. Now here the lordships. On the same subject matter lawsuit, there's a number of cases pending where the department has already sought the opinion of the Advocate General. That opinion was given. And now the department is considering getting the views from the finance department. So the matter may take some time, lawsuits. It's at a government level that considering is going on lawsuits. In item 45, I think notice is yet to be served.
Sure.
Had
His name
Mr.
is-
Legal Counsel appearing for the petition. Matter pertains to non-compliance of the order dated 2016-2021, first in WBC number 1271 of the 2021. By the said order dated 2016-2021. The court directed the respondent authorities to verify the claim of the petitioner as to whether he fulfills the requisite conditions to get one increment, benefit of one increment on completion of his B.Ed degree. Mr. Sisti Standing Counsel, Department of School Education, placed before the court a communication dated 08/02/2023 of the Director of Secondary Education, Assam, to apprise the court that the matter regarding the giving of such benefit of one increment on completion of B.Ed degree, on obtaining a B.Ed degree, is presently pending with the Finance Department of the state.
No, presently at a secretariat.
Presently at the Secretary for its onward
submission to
the Finance Department of the state
for their views.
For their necessary views. Issue notice returnable by 8 weeks. Petitioner shall take steps to register proceeding by tomorrow or take necessary action. Mr.
49 is just one.
49 also. Not
No, there are already notice have been issued. No problem. List. Baki kita allow with case code. Next.
I'm sorry, my lord, I could not.
Yes, Mr. Roy, what's the matter about?
My lord, this is in respect of an appointment, my lord, selection and appointment. Now here the petitioner, my lord, who applied for lordship, may see the advertisement first, my lord, which is at page 24, my lord.
Yes.
Now, my lord, we are concerned about, my lord, serial number 3 and 4, my lord. That is laboratory bearer, 4 post, my lord. And the roster point 4 is unreserved, 5 is STP, 6 is OBC, and 7 is unreserved. And then grade 4, 1 post, my lord. That is roster point number 3 unreserved, my lord.
Now what happened?
And all these 2, my lord, are grade 4, my lord. Laboratory bearer as well as the grade 4, my lord. Now qualification, my lord, if you lordship see the second para, the last, my lord, for grade 4 and laboratory class 8 pass, my lord. Working experience in provincialized college will preferable. Now, in person with this advertisement, my lord, lordship may see, my lord, written test was called for page 26, my lord. Page 26, Lordship may see that candidate has been selected for appearing in the written test that will be held on 22/1/2023. Now, in written test, Lordship may see laboratory assistant roster point to my lord, OBC my lord, then my lord laboratory bearer. Now, we are not connected to laboratory, we are not laboratory bearer my lord. I am there my lord. My name is at serial number 2 my lord, Lordship may see. And one respondent number 7 is at serial number 10 my lord. I'll come back to that my lord. Similarly, my lord, roster point 5 STP, I am not concerned, my lord. Then the next page, Lordship may see roster point 6 OBC. Now, I also OBC, my lord, and Dibakar Kotoki, he is also OBC, my lord. My position at serial number 2 and Dibakar Kotoki, serial number 4, my lord. Now, then again, laboratory bearer, my lord, unreserved also I applied, my lord. Pranjal Handy, Lordship may second, my lord, serial number. And Dibakar is a serial number 11. And grade 4, I have not applied, my lord. They here Dibakar Kotoki, respondent number 7 appeared, my lord. So basically, my lord, I am fighting for Lordship may say unreserved category, my lord, as OBC, my lord.
You are for laboratory bearer roster point 4. 4, my lord. Unreserved. 4 as well as my lord 6 for OBC and 7 and 7 unreserved. Unreserved, right? Yes, my lord. Okay. Now, my lord, out of the 4 posts, you are compelling for 3 posts. 3 posts, pardon. Absolutely. ST, I am not there, my lord. No, it's okay. My lord. Now, Lordship may see the next page is page 28 is my admit card, my lord. I'm not bothering your Lordship. Lordship may come to page 29, my lord. Computer test, my lord. Viva voice for grade 4 and laboratory bearer, my lord. Here, Lordship may see category 4 lab bearer. Here, my lord, my position, the serial number I am at 15, my lord. Pranjal Handy. And Dibakar Kotoki serial number. Now, interview is on 14/2. Lordship will mark this part, my lord. Grade 3, grade 4. 14/2/2023, 9 AM is the interview date, my lord. Viewer voice. Now, what happened, my lord? Lordship may come to page 31. Now, that respondent number 7, Dibakar Kotoki, my lord. Where is the for the laboratory bearer and grade 4? Where is the post?
Yes.
Where is the selection? 14/2.
14/2. 14/2, my lord. 14/2 is the interview date. Now, here the thing what happened, my lord, with Lordship may come to page 31, my lord. Now, this Dibakar Kotoki, my lord, who was actually, my lord, venturing his position in, my lord, unreserved as well as reserved, that is roster point 3, 4, 6, and 7, my lord. 3, 4, 6, and 7, my lord. Now, he, my lord, writes a letter to the governing body, my lord. With due respect and humble submission, I would like to inform you that I, Dibakar Kotoki, had applied in the post of grade 4 roster point number 3 and grade 4 laboratory bearer roster point 4, 6, and 7 of your college. As per your calling, I appeared in the interview on 22/1/23 and also in Viva held on 14/2/2023. On the day of interview, according to the advice, Lordship will mark this portion, advice and suggestion of the interview committee, I signed a letter mentioning that I am withdrawing my candidature from the post grade 4 roster point number 3, grade 4 laboratory bearer roster point number 4 and 7. But after consulting with my family members, I came to know that was my wrong decision to withdraw on that day. In such a situation, in that midst of tension and anxiety, I was unable to take any right decision and did whatever recommended by the committee on that day. But today, with my conscious mind, I am cancelling that withdraw on 14/2/2023. So that is on the date of the interview, my lord. The result has not been declared. So on the advice, that means, my lord, there is something cooking up, my lord, among the respondent, the governing body, my lord, the principal and other members. So he has been asked to resign from these roster point number 3, 4, 6, and 7, my lord. 3, 4, and 7, my lord. Sorry. 6, my lord, he would have been considered. But 6, I am also OBC, he is also OBC. Now he has been asked to resign from roster point number 3, 4, and 7. Now, Lordship may see the interesting, my lord. I made a representation, my lord, at page 33, my lord.
Then what happened?
Yes, my lord. Finally, my lord, after my representation, all that, I have said that there is no governing body resolution and all that. that there was no result declared, my lord. I made RTI also, my lord. Then, my lord, after this, my lord, lordship may see at page 48, my lord. I came to know, my lord, the names of, without declaring the result, my lord. The governing body, that is the principal, has forwarded the name, my lord. If your lordship, I have a photocopy of the register which indicates that the names has been forwarded, my lord. If your lordship see 48, the type copy, my lord. Approval dated 17/2/2023. So intimating that, my lord, on 17/2/2030, governing body resolution has approved these names on the right hand column. Submission of resolution of governing body for appointment of liability bearer Bonita Chaudang unreserved 7, then OBC Dibakar Koteki 6, then Surat Sonwal STP, then Rupam Changmai, my lord, liability bearer, then Jaswanta Changmai. If your lordship now see for a moment page 50, my lord. In all respect, my lord, there could not have been any governing body resolution, my lord. If your lordship come to page 50, my lord. This is a letter dated 16/2/2023. That is, this has been sent by my lord principal to Diganto Gogoi, vice principal, Tingkong College, regarding meeting of the, with reference to the subject cited above. I hereby want to inform you that urgent meeting of Tingkong College governing body will be held on 21/2/23 at 11 AM. Therefore, you are now, my lord, if 16/2 this is the letter, then 17/2 there is no question of a governing body, my lord. This list could not have been forwarded to the approval committee, my lord. And this does not indicate that whether it's a governing body or the principal has forwarded the names for approval. This is my simple case, my lord. And lordship may see, the rule says, my lord, the Assam College Employees Provincialized Rules 2010. If your lordship see, but rule 5(7), my lord, in all these cases, the governing body shall conduct the selection process and recommend to the director, who shall issue orders of appointment. Then direct recruitment 7, my lord. All appointment either by direct recruitment or by promotion shall be made by the director on the basis of the recommendation of the governing body, based on the recommendation of the selection committee, department promotional committee duly constituted. And the director shall communicate his order within 30 days.
Where is that government letter of 28th of July 2022?
That is, my lord, we could not.
Mr. Roy, just a minute, huh? Just.
My lord. I know, I understand. I understand. My lord, my lord. July letter.
That's it. Frame under the act.
Yes.
So by notification, they cannot remove.
They cannot. So I'm not pushing that. Anyway, my lord, now the question comes, my lord. The first thing is that, my lord.
Where is higher education?
But he said that he is just coming, my lord. Well, on the date of my lord,
as of now, matter is pending before the director of higher education.
Director for approval.
What Mr. J. Roy, and senior counsel, assisted by Mr. Counsel for the petition. Also heard Mr. Standing Counsel higher education for the respondent numbers 1 and 2. Matter pertains to selection and appointment to the post of laboratory bearer and grade 4 on college Income district Dibrugarh, advertised on 23/11/2022. principal come secretary of college. Amongst others, advertised 4 posts of laboratory bearer within wicket grade 4, including roster point number 4, unreserved. Roster point number 5, procedural type planes. Roster point number 6 for OBC, and roster point number 7 for unreserved. And 1 post of grade 4 at roster point number 3, unreserved. The petitioner, along with others, including the respondent numbers 5, 6, 7, 8, 9, 5 to 9. Also applied for the same post. Petitioner applied for post of laboratory bearer at roster point number 4, unreserved. Roster point number 6 for OBC. Roster point number 7, unreserved. Whereas the respondent number 7, please take your seat, Mr. Tavi. 7 applied for the roster point number 4, unreserved. Roster point number 6, OBC, roster point number 7, unreserved, as well as the grade 4 post, laboratory roster point numbers, and also for grade 4 post at roster point number 3. The petitioner has reliably learned that on 21/02/2023, the respondent number 7 submitted an application before the governing body of State Income College, Recruitment, stating that he applied for the post of grade 4 roster point number 3 and as well as for grade 4 laboratory bearer at roster point numbers 4, 6, and 7. In that college as advertised on 23/11/2022. The petitioners on being called for appeared in the written test held on 22/01/2023. Same post, as well as for computer test on 14/02/2023. The respondent college authority is yet to declare the result of the same selection. Respondent number 7 on such and such as right submitted an application before the governing body of such and such college on the contrary, stating that he appeared in the written test held on 22/01/2023 and also for Viva Voce held on 14/02/2023. And that on advice and suggestion of the interview committee, he signed a letter stating that he had withdrawn his candidature from the post of grade 4 roster point number 3 and grade 4 laboratory bearer roster point numbers 4 and 7. And after consulting with his family members, he came to know that his decision was wrong, that his decision to withdraw his candidature for those posts was wrong on that day in such a situation. And as such, by the said application dated 21/02/2023 petitioner and the said respondent number 7 intimated the governing body of the said college regarding his cancellation of withdrawal of his candidature on 14/02/2023. In the meanwhile, the petitioner submitted applications before the Director of Higher Education Assam on 23/02/2023. 7/02/2023. Model 4/20. Submitting the said letter of the respondent number 7 written to the governing body of college pertaining to withdrawal of his candidature created a suspicion in their mind, in the mind of the applicants for the candidates for the suit post, that the selection process was not free and fair. And rather, the member of the selection committee conducting the entire process of selection at the behest of someone else and to accommodate their interested candidates. As such, by such representations, the petitioner came before the Director of Higher Education Assam before according any such approval and issue appointment to the aforesaid grade 4 post advertised on such and such. To pass an order for an inquiry into the matter of selection to the single post of grade 4 and the grade 4 post 4 require for your post of laboratory bearer of Tikong College advertised on such and such. By placing the annexure 12 relevant portion of the copy of the peon book / office peon book Tikong College. Petitioner placed before the court that the authorities of the respondent college recommended the respondent number 5 or laboratory bearer roster for unreserved criteria roster point number 4. That's one number 5. Laboratory where roster point number 575 plain. Rest number 7. Or laboratory bearer roster point number 6. And leave a comma. That's for number 8. For a laboratory bearer, roster point number 7 unreserved category. And the rest for number 9. One post of grade 4. Roster point number 3 in unreserved category. Further, by placing a communication dated 16/02/2023 of the principal of Pincom College, Annex 13 to this petition. Petitioner, please before the court that the governing body had its meeting on 21/02/2023. Terms of communication dated 16/02/2023. And as such, there could not have been any such meeting of the governing body. You said the previous day or prior to
On
that?
17/2, my lord.
On 17/02/2023. Where from you are saying?
On page 48, my lord. If your lordship see, TC approval so and so dated 17/2/23. It is reflected in the Peon book also, my lord. Page 49.
From the vendor that there is an approval on 17/02/2023 of the same governing body of the Assam College employees within bracket provincialized rules 2010. Framed under section 12 within bracket 1 of the Assam College employees within bracket provincialization act 2005. As a statutory force. Rule 5 and 7. Rule 5 of say 2010 relates to method of recruitment. And Rule 7. So 2010 rules prescribes for direct recruitment. Rule 5 within bracket 2, amongst others, provides that in respect of grade 3 and grade 4 post, the list of candidates shall be collected from the local employment exchange / advertisement in newspaper. Rule 5 within bracket 5 provides that the post of lower division assistant, laboratory assistant, library assistant shall be filled up by direct recruitment and from laboratory bearers, library bearers, grade 4, having qualification as prescribed in the ratio of 75:10. Rule 5(7) provides that in all these cases prescribed under Rule 5, the governing body shall conduct the selection process and recommend to the director who shall issue the orders of appointment. From the above provision, it can be seen that the recruitment to the post of grade 4 in any such provincialized college as provided in the state 2010 rules is by way of direct recruitment. Rule 7 provides recruitment reads as follows. From the perusal of the Rule 5 and Rule 7 of the say 2010 rules, it can be seen that it is the director who is the concerned authority to issue necessary appointment orders to grade 3 and grade 4 staff for provincialized college of the state. That too on the basis of the recommendation of the governing body, based on recommendation of the selection committee, departmental promotion committee duly constituted. In such decision is taken by the Director of Higher Education to appoint any such grade 3 of the grade 4 on the basis of selection. The petitioner cannot state that it has any such right for its selection, since it is the Director of Higher Education Assam on proper scrutiny shall issue the necessary appointment order that being selected by the selection committee and recommended by the governing college council. Considering the prayer made by the petitioner at this stage on premature. However, the petitioner may approach the Director of Higher Education Assam for the disallowed responses regarding the process of selection and appointment to the post of grade 4 library bearer advertised on such and such income or district. In the event of filing such representation / application before the director on or before 30/03/2023, the Director of Higher Education studying the verification such selection process and after giving an opportunity of hearing to the petitioner as well as respondent numbers 7 to 9, 5 to 9, if so, such verification passes present order regarding the selection and appointment which are at the post of 4 post of grade 4, 4 post of library we have in vacant grade, and 1 post of grade 4 intimating the petitioner about the outcome of this petition. The petitioner honorable such and such along with the certified copy of this petition and the first representation.
Honestly, my lord, no approval should be given till that representation. Otherwise, my lord.
Only after such new verification and such Director of Higher Education.
And lordship, one place mentioned that computer test, it's a Viva voice, my lord, that may be correct. Because is there the obliged.
Mayor, please, Lordship. Engage senior counsel is on Lakes in Kodam 5, my lord. Also for the timing.
For timing, my lord, he is coming well.
I'm sorry, my lord. I kept your lordship's name. My lord, I have filed an additional affidavit for another point. let me deal with the points which my learned friend, learned Advocate General asked the other day. My lord, let us be very clear on one point. All the judgment which has been referred by the learned Advocate General, my lord, these are all 3F appointment as we understand. Some minister giving a note without any process, my lord, somebody is appointed. Then, my lord, those 3F never, and my lord, my learned friend referred to many judgments for the proposition that 3F appointment does not confer any right. Where is the difficulty, my lord? Whose case is it? In fact, I am with the learned Advocate General on those submissions. Our case is, my lord, because the post was a sanctioned post, this was a substantive post, because following, I mean, that institution has come up, that's why posts were sanctioned. That's why, my lord, we are appointed. That too by following a definite procedure consistent with Article 14. In such a scenario, what would be the legal position? My lord, while opening my argument, I referred to the judgment, my lord, of Pratap Kishore, that is 2015-17 SCC, which says, my lord, this is an alternative mode of recruitment. But to equate with those, my lord, backdoor appointment, it will not be correct. My lord, all the judgment which was referred by my learned Advocate General, these are all judgments on those 3F appointments who were appointed without there being any process being followed. In fact, my lord, be it Uma Devi, be it my lord ML Kesari, these have all made a distinction between what is an out and out illegal appointment and what is an appointment by following some procedure of law. Therefore, my lord, to say that our appointments were illegal appointment, that will not be correct. Now, my lord, I'll rely upon one judgment of this Honorable Court today. 2022 6 GLT 389. My lord, 2022 6 GLT 389. Last time to me the movie. Okay. GLT report which. Yes.
6 is not available.
Oh. We have a copy, madam.
Up to 5 it is available.
That's what I was thinking, madam. Maybe they will upload it next time. A single judge of this Honorable Court, my lord, in a similar circumstance has said such appointment has to be construed as a regular appointment. Please come to para 70, 71 and 72. Para 70, my lord, regulation 3F is quoted. Now please come to 71. A reading of provisions of regulation 3F makes it discernible that the provisions thereof are applicable in case of a direct recruitment to a temporary post created in service, if it is so necessary in public interest that the appointment should be made immediately and reference to commission would cause undue delay. In other words, whenever in exigencies of public service, administrative authority are of the view that there is a necessity for creating a temporary post, and such temporarily created posts are to be filled up by direct recruitment, and the authorities are of the view that reference to commission for such appointment would cause undue delay, as because the appointments are to be made immediately, the authorities can resort to the provisions of regulation 3F of regulation of 51. Well, this Honorable Court has clearly said 3F can be invoked only in case of a post which is likely to last for more than 4 months. If a post is to be continued beyond 4 months, then there cannot be any question. And secondly, if the post is sanctioned post, then there is no question of invoking 3F. The regulation, para 72, regulation 3F of regulation of 51 itself provides an inbuilt limitation that in the event the post that had been created temporarily is likely to last for more than 4 months, the commission as soon as possible be consulted as required under Article 323 of the Constitution of India. In other words, condition precedent in making an appointment under regulation 3F would be that it cannot be against a permanent sanction post already in existence. And on the other hand, it can be invoked only in a situation where administrative authorities are of the view that for the purpose of administrative exigencies, posts beyond the permanent sanction post are required to be created, and such posts on being created would last for a period lesser than 4 months. And in such situation, there can be direct recruitment for which no consultation with APSC would be required. If the posts so created in administrative exigency are required to exist for a period beyond 4 months, then mandatory consultation with APSC would require to retain further continuance with such direct recruitment. In other words, Regulation D pertains to a promotion which is likely to be for a period of lesser than 1 year. And for such promotion, there would be no requirement for a consultation with APSC, whereas Regulation 3 pertains to a direct recruitment to a temporary created post which will remain in existence for a period less than 4 months, for which no consultation with APSC would be required. To the corollary, we also find on one hand, Rule 12.7 of the Rules of 82 require approval upon consultation of APSC, and on the other hand, the provisions of 4D of the regulation is read into proper perspective. Such promotion made under Regulation 4D are not required to be sent for consultation of APSC, and in such a situation, if promotion is otherwise not promotion under Regulation 3F, is referred for consultation of APSC, an inconsistent and incoherent situation would arise, which will result in a conflict between the two provisions of law. Now, para 75 is important. Having arrived at such a conclusion, when we examine the notification dated 8/7/14 by which the petitioner was promoted to the cadre of Joint Director under Regulation 4D, it is discernible from the records that firstly, no satisfaction was arrived at that promotion to be meted out would be an officiating promotion, and further that the said promotion is likely for a period less than 1 year. In other words, both conditions precedent to make the promotion under Regulation 4D of the Regulation of 1951 is not satisfied in the present case, and accordingly we have to understand that although the expression 4D is incorporated and referred to in the notification, the promotion meted out to the petitioner would not be a promotion under Regulation 4D, and on the other hand, it would have to be accepted that said promotion is a promotion otherwise than that of Regulation 4. In other words, my lord, this honorable court came to the conclusion that since condition precedent required for invoking 4D being not present, the appointment though described, the promotion though described as under 4D, it has to be constituted to be a promotion other than under 4D, meaning thereby some alternative method. Now, my lord, coming to the facts of the present case, my lord, there was an advertisement. Yes, it was said 4D. Because it was said 4D, it will not take the color of 4D, my lord. That in my humble submission is the ratio of this case, my lord, subject to what your lordships may say. The ratio of this case is, no matter how you may describe the appointment or the promotion, it will take its color from the substantive nature. In other words, what is of essence is the substance, not the form. And my lord, kindly see now in this context, kindly have a look at the, my lord, post ex post approval of the cabinet at page 59. Now, my lord, the other side may like to say, make so many arguments, but we'll have to go by the language of this. Kindly see, my lord, in the interest of public service at page 59, and in pursuance of this department notification dated 17/2/21 and cabinet decision held on 24/11/21, Governor of Assam is pleased to approve as post facto appointment of the following assistant professor of the Dhemaji Engineering College, appointed under Regulation 3F, with effect from the date of joining on usual pay and allowances as admissible. And there is no outer limit, my lord. Meaning thereby, the appointment also has the ex post facto approval of the cabinet. Now, it is in these circumstances, my lord, your lordship is now required to deal with this appointment and to give a conclusion as to whether, though it is described as 3F, it is a 3F appointment or it is an appointment other than 3F. If it is other than 3F, certainly, my lord, the contention of what the other side has said perhaps cannot be accepted. At least, my lord, there is one authority of this honorable court which dealt with the issue. Now, it is for your lordships now take a call, my lord, but my humble submission is this is squarely covered by the said judgment. This is one aspect. Now, my lord, I have filed the additional affidavit. Before the affidavit, my lord, education. Now, my lord will kindly take this education technical service rule, my lord. It is 81, na? 741. My lord will kindly have page 741, my lord. That's the rule. My lord will kindly come to page 745, rule 6. Subject to sub-rule 2 of rule 11, direct recruitment to the cadres as mentioned in sub-rule 4 and 5 of rule 5 shall be made by the governor on the basis of the recommendations made by the commission in accordance with the procedure hereinafter provided. So, my lord, the selection will have to be made by the Assam Public Service Commission. Now, my lord, now the instant selection has been made by a body, my lord, which has been created by virtue of a, my lord, notification issued by the government purportedly under Article 309. My lord, before I make my submission, I'll invite your lordship's attention to, my lord, my additional affidavit. Huh? My lord will kindly come to page number 83. My lord will kindly come to paragraph 4, my lord, at page 83. That the deponent respectfully begs to state that Constitution of Assam Engineering Service Recruitment Board itself a nullity inasmuch as board cannot be entrusted with the functions of Public Service Commission within the meaning of Article 320 of the Constitution of India. It is needless to point out that in exercise of power under proviso to Article 309 of the Constitution of India, the government of Assam could not have framed the Assam Engineering Recruitment of Board Regulation 2021. That regulation 3 of the aforesaid regulation envisages the board which has been tasked with the responsibility of making recruitment of teachers, faculty in engineering institutes, given in Schedule 1 of the regulation. That the deponent states that Article 320 of the Constitution of India provides that it shall be duty of the Union and State Public Service Commission to conduct examinations for appointment to the services of the Union and the services of the state respectively. Article 323 further provides that Commission shall be consulted in all matters covered under subclauses A to E thereof. Proviso to Article 323 provides that Governor may, in respect of services and posts pertaining to the state, may make regulation specifying that it shall not be necessary for Public Service Commission to be consulted. There is no dispute that regulation referred to above has not been framed in exercise of power under proviso to Article 320, and hence the board constituted on the basis of the regulation cannot take over the function of the commission in the matter of recruitment as laid down in Rule 6 of the Assam Technical Service Rule 1981. Rule 6.1 specifically provides that subject to sub-rule 2 of Rule 11, direct recruitment to cadres as mentioned in sub-rules 4 and 5 shall be made by the governor on the basis of the recommendation of the commission. That Article 320 was incorporated in the Constitution by the Constituent Assembly in exercise of the constituent power. It is right law that a provision incorporated in the Constitution in exercise of constituent power cannot be overridden by the Parliament in exercise of its ordinary legislative power. Having regard to the above, it is inconceivable that regulation could have been framed by the state of Assam in exercise of subordinate legislative power conferred by proviso to Article 309. It is also a trite law that every law, be it primary legislation or subordinate legislation, must withstand the constitutional test. The statutory authority failed to notice that Article 309, which has been invoked to frame regulation, starts with the phrase subject to the provisions of the Constitution, meaning thereby exercise of power by the governor under proviso to Article 309 is subject to the provisions of the Constitution, that is Article 320 and Article 14 amongst others. That having regard to the above legal position, the impugned advertisement dated 21 to 23, which has been impugned in the present proceeding, is non-est in the eye of law. In other words, as the law obtains, it is the Public Service Commission which is competent and authorized to make the recruitment and not the board. Therefore, impugned advertisement is bad in law. My lord, it's a very, very simple case. My lord, it's an open and shut case in that regard. My lord, governor, my lord, in exercise of proviso to Article 309, they cannot frame a regulation to, my lord, overreach a constitutional mandate. Yes, had it been a case, my lord, now if your lordship would kindly take the constitution, my lord. Please come to Article 320, my lord.
Yes.
Functions of the Public Service Commission. It shall be the duty of the Union and State Public Service Commission to conduct examination for appointments to the services of the Union and services of the state respectively. It shall be duty of the Union Public Service Commission if request. And three is important, my lord. Union Public Service Commission or State Public Service Commission, as the case may be, shall be consulted in all these matters from A to E. Now, my lord will kindly come to the proviso. This is very important. Provided that the president, as respects all India services and also as respect other services and posts in connection with the affairs of the Union, and governor as respects other services and posts in connection with the affairs of the state, may make regulation specifying matters in which either generally or in any particular class of case or in any particular circumstance, it shall not be necessary for the Public Service Commission to be consulted. Now, my lord, power has been given, but it has to be under proviso to Article 323, not, my lord, under 309 proviso. Now, my lord, most importantly, please come to 5. There is a requirement of laying these regulations before the House. All regulations made under proviso to clause 3 by president or governor of a state shall be laid not less than 14 days before each house of the parliament or each house of the legislature of the state, as the case may be, as soon as possible after they are made, and shall be subject to such modification, whether by a repeal or amendment, as both houses of the parliament or houses of both houses of the legislative assembly may make during session in which they are so. So not only, my lord, the regulation will have to be framed in exercise of power under proviso to Article 323 in order to, if the governor or the state decides that certain post is to be taken out from the purview of Public Service Commission, and those regulations will have to be laid before the House. Now here, my lord, an executive exercise has been undertaken. That too, to overcome, my lord, is a constitutional mandate. Lordship knows, my lord, in Sankari Prasad, Goloknath, Keshavananda Bharati, these 3 cases specifically dealt with, my lord, the constituent power and the ordinary legislative power. And in all the judgment in unison, it says, my lord, a law made in exercise of a constituent power cannot be amended by exercise of ordinary legislative power. That is why it is said, my lord, why we say this law is ultra vires the constitution. That is the underlying reason, my lord. It was said in my lord Shankari Prasad's case. Therefore, my lord, this body, the board which has been constituted, is absolutely non-est in the eye of law. They cannot undertake, my lord, any recruitment, my lord. So, my lord, state governments should have noticed all these things before coming up with this regulation and the recruitment board, my lord. Therefore, my humble submission is, my lord, not only that our appointments are to be construed not as 3F, but as an alternative mode of recruitment. Even the recruitment which is sought to be undertaken by the, my lord, board is, my lord, in my humble submission, honest. Therefore, my lord, lordships will have to hear this matter and interdict the authority from going ahead with this election. That is my humble submission. And at the time of hearing, my lord, I'll come up with all the case laws. Of course, my lord, I must give say one thing. This point was not brought in the petition. Therefore, my learned friend may not have got the opportunity of dealing with it, my lord. Therefore, if my learned friend feels that matter should be taken up on another date, my lord, I have no objection, my lord.
So actually, in the reply, Lordship, all these new points has been brought into argument. Yes, now the thing is that suppose this board is illegal, suppose they will have to challenge it. This board, as on date, under this 309 rule, it is in existence. To make this board inoperative, Lordship, there has to be a challenge to that board. We'll argue on all legal points, but if it is challenged, then it will have to go to the division bench. So they cannot have both sides, Lordship. If they are really aggrieved by this constitution of this board, Lordship, they have to challenge it in a proper forum, in a proper manner.
Challenge the advertisement.
Yes, so they have challenged the advertisement, perfect. But now they are saying that the board is illegal or unconstitutional or dehoards the provisions of 309, or I do not know what are the other arguments made.
No, because it is Article 320 who provides for public service commission.
320, but what is that there? No, Lordship, I know what is 309, 320. I'll argue on
3203 that provides you that part has to be required.
Absolutely, Lordship. In that case, Lordship, there has to be a challenge to the board. This rule of 2021, 23rd June 2021, if it is illegal, it is unconstitutional, it is ultra vires, Lordship, it has to be challenged. Without the challenge, all these arguments have no meaning. Earlier rule was also made under 2309 rules. And whatever procedure is to be followed for bringing these 309 rules, I'm sure everything was followed.
Earlier, 309, there was a specific provision at Rule 6.
I fully understand. I will argue on every point, provided it is put to challenge in the right forum and in the right manner.
If an advertisement is against the board, let's clear. My lord, sorry, my lord. There is a judgment of Honorable Supreme Court, my lord. I'll get that. Where Honorable Supreme Court clearly said, if an advertisement is dehours the rule, my lord, then advertisement can be challenged. Now the advertisement is dehours the constitution. I'll place that judgment, my lord.
So let them, will file a detailed affidavit, Lordship. Let their writ petition be complete first.
No, my lord, we are urging an additional point for which we have filed an additional affidavit. That's all. It is nothing new, my lord. We have not done something which is so abhorrent. We have urged additional point, therefore we have filed an additional affidavit.
Let them make their complete arguments, Lordship. Whatever judgment they want to show, whatever line of arguments they want to make, let them complete. Because first they argued the case, we give a response, then there's just opportunity for reply. Now again, to the reply, I have to give a further reply. So it cannot continue like this seesaw manner. Let them complete once, then we'll give our proper, and in a consolidated manner, we'll argue our case.
Today, this is a surprise. I was not supposed to come here now, but I am told that a new point has been brought with a new additional affidavit. So I have no objection. If they want to challenge the board also, Lordship, we know how to defend it, but it has to go to the division bench. The High Court rules are very clear on this. And this is a rule under 309. So the challenge has to be before the division bench, not before the learned single judge. If they want to, and without this point, they can argue their case here. If they want to enhance their argument, if there, in fact, there is no challenge, there is no such prayer. And surprise, Lordship, at least we have to have some semblance of norms in the repetitions also. If there is no challenge, if Lordship is pleased to look at the prayer at page 28. Yes, after paragraph 31, the prayer does not consist of all these new things. So if the advertisement is bad because a board has been constituted and board has been entrusted to do the selection instead of APSC, Lordship, then they have to put a challenge to that board. Now, as on date, the board is in existence for the purpose of recruitment of persons in the engineering services. The earlier rule has been substituted. So I leave to the wisdom of this honorable court, Lordship.
By way of reply, I'll only make one small submission, my lord. If an advertisement is rehearsed the rules, my lord, there is no requirement of challenging the rule. Yes, my learned friend is correct when he says if we are to challenge the regulation, then this challenge will lay before the division bench. We are conscious of that, my lord. But the question is, we have challenged the advertisement. Now, who the authority who has issued the advertisement, it has no authority. Why should I challenge it unnecessarily, my lord? I may, ideally I should. Supposing I don't, will my challenge, my lord, be fatal? At the end of the day, power of your lordships under 226 is not bound by any other provisions of law. It is by the constitution only, my lord. If constitution imposes any fetter, yes. When an illegality comes to your lordship notice, lordship can certainly take note of. It is not a civil suit, my lord, that we have not filed this, we have not filed that. At the end of the day, lordship will see that justice should not only be done, it must be seen that justice is done. So here we are a simple case is, my lord. Number one, our earlier appointments cannot be construed as 3F, though it has been described as 3F. And secondly, my lord, the authority which has issued the advertisement is non-est. These are the 2 points. Therefore, my humble submission is, my lord, lordship will not permit the authority to go ahead with this election.
Article 323.
And my lord, in all the cases, all the petitions where I am appearing, all the petitioners were selected following advertisement. It's not those 3F appointments as we commonly know, my lord, or commonly understand. In all cases, there were advertisement. These were all sanctioned posts. There were selection procedure. Following selection, we are appointed. And my lord, in all the cases, there is ex post facto approval with effect from the date without there being any outer limit. So some meaning has to be given to that also. And my lord, we are getting regular scale of pay. Apart from teaching, we are doing other duties which is required from time to time. That is my humble submission, my lord. My lord, if your lordship wants the judgment, I'll give tomorrow, my lord. Where Honorable Supreme Court says, my lord, if advertisement is rehearsed any provision, then my lord, there is no requirement of assailing the rules, my lord. Tomorrow morning, I'll give my. We hand over
Lordship, kindly give me 2 weeks time. We'll file a detailed affidavit. Okay. On that day, interim order may be considered.
And till then, my lord, if they proceed, they will not finalize, my lord.
That interim order, I am vehemently objecting, lordship.
Oh.
We'll dispose it of.
Lordship.
We'll dispose it of.
Lordship is going to dispose. Yes. So 2 weeks time or 1 week time, Lordship, maybe please to give me.
Your submission is enough? Or
My
you want to
submission
put-
is enough. Yes, yes.
Submission is enough.
Lordship.
Anything else?
Essentially,
And
these are all
I don't
legal
have
issues.
any.
Already given the citations, judgments.
Yes, yes.
This
Otherwise,
is
my submission is that it is not maintainable before this point is not maintainable here. And to that point, Lordship, the High Court rules also I can cite.
No, regarding this 309 and 323.
Yes, I have gone through it, Lordship. If that is the argument, Lordship, then all our recruitments in all departments will have to come through APSC. That
No,
argument
that is not,
sustained.
that is not my argument. Again, my learned friend is me. I am never, I say.
We'll clarify.
That is not my argument, that it is your choice, whether you make recruitment by public service commission
So
or
I
by
leave it to
somebody
this
else.
honorable court.
If you want to make by somebody else, then there is a procedure, how can you do it? If you do it in a manner which is not recognized, then court will interfere.
Mr. Devon, advocate in Assam, for the respondent of assisted by assisted by Mr. K. Bogoi. Higher education, technical. For the respondent numbers 1 to 4. APC, somebody.
My মনে হয় আগতে মোৰ মোশন আছে ইলেক্ট্ৰিচিটি বৰ্ডৰ মোশন আছে
By next Tuesday, we'll pass the order. Lordship.
Highly obliged, Lordship.
Deep.
Make visual losses. I have filed one vacating petition, my lord. Lordship kindly turn page. Well. In this case, my lord, I have been appointed as a Hindi teacher, language teacher, my lord, as tutor, my lord. And I joined as a Hindi teacher, my lord, in that school, my lord, from the beginning, my lord. And my appointment letter is page annex 520, page 21. And I joined and I have been working. Because of that case, my lord, petitioner is suffering. She did not get the salary, my lord, after passing this order, my lord. And lordships kindly turn the page in the writ petition, my lord, page 17. The particulars of the Venture school, my lord. It is shown that the petitioner's name is, he was appointed as an assistant teacher. And I am appointed as a Hindi teacher, my lord. And language teacher is must, my lord, in upper primary.
Show that you've been teaching Assamese.
My lord, the fact here is that this particular is my lord of 2005, my lord. So I was my lord that at that moment my lord as an assistant teacher, but I have approached my lord to the concern authority for my lord occasion to my lord send to provide me that my lord particulars that have been forwarded. That is not my lord provided to me by the headmaster. And also my lord because my lord there was an order passed in this petition also. My lord this interim order has been passed after going to the record. My lord the honorable court on very inception my lord the record was called for my lord. Thereafter, Lordship may kindly see that order, my lord. The path that order is there. So I'm, my lord, being, my lord, I'm Assamese, my lord, and I'm 20 years, my lord, 10 years seniority, my lord. And I'm the, my lord, that my service has not been provincialized, my lord. Hearing that, my lord, procedure, my lord, fact hearing is that, my lord, two teachers has been only two teachers provincialized, my lord. One teacher, my lord, who has attained the, my lord, date of superannuation, my lord, in the year 2020, my lord. That is respondent number 6. Respondent number 6, the headmaster, he has attained the age of superannuation at the in the year 2020. His service has been provincialized, and this is respondent number 2. Lakshmi, can you just take a note the manner they have made this recommendations, all this selection and all. Similar matter here in this malon. So Lordship, a similar matter has been disposed of here in my lord.
If you go for appeal, my lord, appeal provision is there.
Similar matter, my lord, but here I was the social science teacher. And some other order is there. Let them get the record, otherwise, man. Subject. I will find that my lord, the name of the teachers whose services has been provincialized, my lord, and on page 28. It is only two teachers, my lord, serial number 225, 226, Sonaram Bora and Niroda Bora. There are two teachers services are only provincialized. And the Sonaram Bora, my lord, the headmaster, he has attained the date of superannuation, my lord, in the year 2020. I have, my lord, annexed some record, my lord, where the block limited education, my lord, officer of Jorhat. In reply of my RTO application, it has been submitted by him that the Sonaram Bora has, my lord, retired. The petitioner is, my lord, I am senior to her, my lord.
My lord, as per Parawas, my lord, his name has been not recommended by the district executive committee. And
DLC has not recommended. DLC has not
the
recommended.
DC
my name, it is
also
correct.
made inquiry, but this recommendation was proper, my lord.
That, my lord, only that is only environment, my lord, not the records. Definitely, my lord, they will apprise their own findings. Otherwise, my lord, I am the senior most teachers. Even if, my lord, it is assumed that I taught any other subject, my lord, then only, my lord, I am entitled. But herein, my lord, on, my lord, very good faith, I am, my lord, fairly submitting that I am, my lord, Assamese. I am not claiming in the social science or any other teacher. Two teachers provincial has only.
The other two copies. In this communication, there are two copies, annexer A, annexer and B.
These
Annexer A and B are with you.
this annexer is
Annexer B. There is annexer A and B.
annexer.
My lord, in all other cases, your lordship, my lord, very much aware and finds, my lord, there is a minute of, my lord, of the recommended teachers. There, my lord, the subject has been very much, very clearly specified in the all the minutes. That is the pro forma, my lord. Which teacher taught which subject, that has been very clearly stated. That will clarify the, my lord, actual fact. Well, the subjects are perhaps there in the next page, annexer B, but it is not legible here. my lord.
For proper adjudication of this case.
Yes, sir.
Yes, Sarva Shiksha Abhijan. Headed by its legal. Incorporated as respondent number 8. Mr. 60 ask anyone from the SSA, either or anyone. B. Gogoi, B. Chaudhary, whoever is. I have. Mr. Chaudhary. Eyes of the school. The school, complete the school. Along with the name of the teachers.
Yes, sir.
Serving in it. At the relevant point of time. So this is a school. Sadopur Sahbagisa ME School from Pitabor, Jorhat. How much time will it be? Because here you will have to complete record probably.
Lordship, week's time, Lordship. Or on fine.
Mr. B. Chaudhary, Standing Council, SSA has entered appearance in the matter. On the next date fixed, the respondent SSA shall place the details of the files pertaining to Jadavpur Sahbagisa ME School, Jadavpur Sahbagisa, Pitabor, District Jorhat. Giving the details, including the list of teachers and the subjects they taught in that school prior to the provincialization of service of the response number 6 and 7 under the provisions of 2017. As on 2019, it should be 2019, right? But the provision says 2019.
Yes, sir.
So we'll make it as of 2019. List on, give us a date, Mr.
Lordship, 20 or 21. 21 later.
On declare of Mr. Chaudhary, please this matter on.
Yes,
Petitioner shall serve 2 extra copies of this petition to Mr. Chaudhary by tomorrow, obtaining necessary acknowledgement from the death. SSA in the context against this item in the respondent column or the respondent number 8.
Lordship, this matter is about the selection and approval of the president of SMDC. The issue raised by the writ petitioner is that the respondent number 6, and I am the respondent number 6, is associated with a political party, and the name of the respondent number 6 was not.
Yes, you have the records from the deputy commissioner and the inspector of schools.
Yes, I think some.
Lordship, picture will be clear if Lordship, the clause 4 of the notification 2016 and the notification dated 5th April 2017, which is on page number 20. These two notifications will make the picture clear, Lordship. That in fact they have filed the writ petition suppressing the material fact. These notifications, which are 2017 and 2021, modified the rule 2016. And it was suppressed while filing the writ petition. Lordship, may I have your permission to read the clause number 4, which is about the political involvement?
We'll come back to you.
Yes.
Yes, which provision, clause 4 of which?
Page number 13 of my application, clause 4. It is about the political involvement of the person. Lordship, it is candidly says that any person who have
Reading at which page?
page number 13 of my application, Lordship. Clause 4 of the notification.
Clause 1, 2, 3, 4. Any person. Yes.
Any person who have contested any election of panchayat level, parliament or assembly election in last 20 years should not be considered for the post of the president, vice president, even if he or she is fulfilled all criteria as indicated above. So picture is clear and it is clarified that clarified in the clause number 4 of the notification that if a person contested election in last 20 years, then he will not be eligible to be selected as a president of the Smdc. And next, in view of the above criteria, the governor is hereby pleased to dissolve all schools. This part is not necessary. One local educated reputed citizen having no political career as a president. Having no political career. And the political career is defined in the clause number 4. That a person who have contested election in the last 20 years, he is not eligible to be selected as a president or vice president. And Lordship, that is true that I was associated with a political party. I have never contested election, and prior to the selection, before selection, I have resigned from the primary membership of the particular political party. And most interesting thing is, Lordship, how they have defended the clause number 4 in their objection. They have stated that when I was the student of some college, at that time I had contested election. And my mother was the elected panchayat member. This is the way they have defended the clause number 4. It is in the page number 3, Lordship will find. Page number 3, second paragraph. Page number 3 of their objection, Lordship. Lordship, may I read the relevant paragraph they have stated?
Not required at this moment. The other document you like to show?
Pardon, Lordship.
You wanted to show another document?
Yes, another document is that, Lordship, the same on the page number 15. It is the second paragraph, selection process of the president and vice president of Smdc. The inspector of school, after consultation with the principal, headmaster, and local people, will forward 2 names to the director, secondary education, Assam, for each president and vice president, with the recommendation of the deputy commissioner within a period of 30 days. So, headmaster is not the authority to recommend someone as a president or vice president. It is the responsibility and duty of the school inspector. Yes, of course, he will consult with the headmaster Thereafter, after a consultation, he will forward the name to the deputy commissioner. Deputy commissioner shall recommend it to the director. But in their case, headmaster proposed the name of the writ petitioner, but it was not forwarded to the deputy commissioner. Neither the deputy commissioner recommended the same, nor the inspector of school forwarded it to the deputy commissioner. So under these circumstances, Lordship, this writ petitioner does not have locus to file this writ petition, because his name was never recommended. It was not, neither it was forwarded to the deputy commissioner also. And Lordship, you find this notification also modified in page number 22, Lordship. This is most important. And by this modification empowered the deputy commissioner to modify the recommendation at his level, without approval of without consultation of the director also. That is, the deputy commissioner is empowered to select anybody as per the criteria as a president or vice president of the school management committee. And while filing the writ petition, they have suppressed the modification. It is not like this that the headmaster proposed someone and his name shall be recommended and approved by the authority. And Lordship, another issue is that the issue they have raised that I am associated with the political party. As I have annexed my resignation letter also, that I have resigned from that political party before my name was approved and selected. But the petitioner, writ petitioner himself also involved and associated with a particular political party. Lordship, if you allow me, then I will submit his visiting card also. And some photographs they have collected from the Facebook. I am not admitting it. It is a disputed.
Mr. Ramali, counsel appearing for the petition.
Sir, may I reply?
Required. Mr. Reference is to standing counsel Department of School Education for the respondent numbers 1, 2, 5, 105. Also heard MS Data's Roman government advocate Assam for the respondent numbers 3 and 4. And Mr. FZ Mazumdar, counsel for the respondent number 7. The respondent number 7 is 5. Connected IAC 371 of the 24 for modification and petition of the order 21/12/2020 passed by court. Whereby the recommendation of his name as President of the Smdc of Markula High School, Markula, district of Balpura. Suspended. They are recommended by Inspector of School Balpura on 16/12/2022. List on second. On the said date, the Inspector of Schools as well as the Deputy Commissioner, Inspector of Schools, Gwalpara, respondent number. The Deputy Commissioner, Gwalpara, number 3, as well as the Inspector of Schools, Gwalpara, District Circle, Gwalpara, respondent number 5. Shall place all the relevant records in original regarding the recommendation of the respondent number 7 as the President of the Smdc of Marpula High School. Copy of this order to Mr. Smdc. Any urgent matter, very urgent matter. Any urgent matter, very urgent matter. We are fixed. That is the reason. If there is some urgent, we'll take up. Otherwise,
Short date may be fixed. This is non-provincialization of service.
non-provincialization.
Lots.
Just a minute.
Item 19, that is beginning slide.
14.
This is provincialization under which act? What is the stand of the government?
Government has not filed any affidavit, Lordship.
What about the stand of the private sector?
There is no private respondent. Lordship, they were left out under the 2011 Act.
Yeah, we have always saw that report, that instruction from the government that is yet to come, Lordship.
The 2019 matter, Lordship. And they were given.
Initially, they have approached the DB, Lordship, that was then. It took place now, division bench of usually.
It was in the division bench, Lordship. Later on, it was transferred to single bench because earlier some 2017 Acts was challenged, some provisions were challenged. Later on, it was we have not placed this provision.
Now, just tell us, Mr. Sisti, whether the names of the petitioners were recommended by the district scrutiny committee
at the period of time.
The period when he was there. And whether that decision of the my brother team provision is in other challenge in the division bench. Whether that decision of the school.
Yes, sir.
That team provision.
Yes.
Is it under challenge in any division bench?
I think one case is prepared whether that was filed by, I have to check it, Lordship. You are supposed to challenge those cases, Lordship.
No,
Yes.
you see, the Honorable Apex could have clarified.
Yes.
Which Mr. Gogoi have placed.
Yes.
You remember that judgment? Once an act is declared to be an ultra vires, gets come from inception, nothing is there.
Yes,
The question of giving provision won't come.
Don't come, yes.
That's a
In fact, that was our argument also in that, in spite of that, those orders were passed.
That judgment was not placed before.
And not placed, yes, at the time.
But judgment was already rendered prior to the decision of this.
Yes.
Right?
Yes.
That is the difference. Otherwise, although that was a thing.
Yes.
But the judgment was not placed. And the Honorable Apex Court that Mr. Gogoi have placed in the last occasion.
Yes, sir.
Mr. Das may be aware. That decision. of the Apex Court.
I have the name, I have the name.
Do you have the name, the decision?
Decision does not.
Because that will be in violation of the law laid down by the Apex Court.
Yes,
That is the
sir.
reason we want to know from you.
Yes, yes.
So if that is a case, that for the petitioners, whether it will be 2017 Act or otherwise.
Yes.
On that day, Mr. Gogoi have placed in the footing.
Yes.
Remember that?
Yes,
It is here with him.
Okram, my lord.
Give us the citation.
Citation is not here because it's a recent one, my lord.
There it is already there. Earlier, just give us the name of the party.
Yes, my lord. It's State of Manipur versus Surya Kumar Okram.
Civil appeal number.
Surya, SURYA.
SURJA KUMAR
Okram, different, separate word, my lord. OKRAM.
Livelihood পাবো নেকি ওর livelihood?
OKRAM.
Yes, sir.
OKRAM and others.
RAN or M?
M for mango.
Meghalaya.
Meghalaya, yes.
What is the civil appeal number?
Civil appeal.
Or SLP or civil appeal?
SLP number 2386-2390 of 2021. Live law to 2022 live law Supreme Court 112. Live law is
When it was decided?
decided
Decided on 1st of February, 1st of February 2022.
2022.
2022 February 21 2022.
Why has it come here?
It is a three honorable three judges.
Ah, yes.
Yes.
But there the judgment is cited.
Yes.
Do one thing, you also go through that judgment.
That's it.
And Mr. Sisti?
Yes.
Go through that.
Yes.
Thereafter find out whether the prayer of the petitioner can be considered in respect.
Short date may be given, that's it.
We are not giving any date. Basically, you see, if the matters are very, very urgent, we'll consider. Otherwise, it will go after the BO vacation.
So some of the petitioners has already attained the age of superannuation. Yes, it is 2019 matter. Any date loss, otherwise it is difficult to release the matter.
There's another urgent matter. There is item number 25. It is
23rd, Thursday.
23rd. Obliged, that's it. March, that's it.
This
Obliged.
item number 25, my lord. Quite urgent matter. The petitioner is going to retire very soon. In fact, actually, I'm the respondent number 4. I'm the senior most, and I've been appointed as a headmaster. But the writ petitioner they have filed, and he is getting the stay order. So
I have this petition.
Yeah.
For item number 25.
25, yes. I'm for the respondent number 25.
Who is for the petitioner?
I don't know.
Petitioner
and I
M Khan. তোমাকে ওখানে ফাইল কৰিলে নাই নামে ছগন
কৰা আছে। And we have filed the WS also, my lord. Affidavit, sorry. Respondent number 4. Lal Bahadur Deori. Appointed as headmaster. That is page number 39. And the page number 38, the serial number 5 and 6. The petitioner is Monikanto Borgoin. The date of receiving a graduate pay is 2004. And I'm getting the graduate pay since 1992. My number is serial number 6, my lord.
Just a minute. You are still holding the, you are still the headmaster.
On record, I'm holding. In physical, I'm not holding.
Why?
Because they have already filed the writ petition here and they got a stay order and
There is no stay order.
no, there is a stay order. There is an order.
Read that order. When that order was passed,
It's no order. This place. Status quo. Status quo.
so
It was status quo was been given, my lord.
that's to when that order was passed.
13/6.
And when you have become the headmaster in charge?
9 June,
9 May.
9 May.
So when you have become the headmaster in the 9 May, how you are the headmaster in charge?
But they are not giving charge to me.
That is a different issue.
So I'm not. Already I have joined also, my lord, in the before that this inspector, school inspector.
Do one thing. Do one thing. On 9th of May 2022.
My lord.
Show us what was your pay scale.
Yeah, my lord.
And the pay scale of the petitioner.
It is already reflected, my lord, in the page number.
We have seen that.
Yes.
Now show us the school was amalgamated on 22nd of August 2017.
My lord.
Prior to that, to RTI you can get it from the district elementary education officer in Chukia. What was the pay scale of the writ petitioner while you are serving as a headmaster of the ME school?
No,
Whether
here
he
is
received graduate scale of pay or he received some other scale of pay at the relevant point of time. That much is sufficient. You have to get it from the.
My lord, there is one report. If this is a report made, school inspector has given a letter to the director of school secondary education, Kailipara Guwahati. Here it is clearly mentioned in the first paragraph, the Monikanto Borgwai is the second senior most. In the second paragraph, that is that madam, in the meantime, the director of secondary education Assam has issued another order, that is Lal Bahadur Devi by number so and so, that is so and so, who is the senior most graduate teacher in the same seniority list.
See, we are not.
This is a letter he has received from the inspector to director, which I have not yet to receive proceeds.
That is the
No, we have obtained it from the.
You go back to the DEO Tinsukia, get the RTI and get the information since when this Minakanto Borgohai, the headmaster of this particular ME school, received graduate scale of pay. And what was his pay scale?
My lord.
On just before, that is on up to 13th of July 2007. Two things you have to get there. Let us know.
No, it is in the list. It
is not there. When did the graduate scale of pay was?
No, it is already reflected there, my lord.
This order of the inspector of schools will not see.
No, here it is.
Because
here. My lord, in my petition, page number 38, it is reflected there.
Page number?
Page number 38, the statement showing the particulars of seniority, here the graduate pay he is receiving on 2004, it is reflected.
Where from he came to know?
No, we have, this has been given from the office.
That is the reason.
And in the affidavit also I have given.
That is the reason we are telling you. Unless it is authenticated by the district elementary education officer in Chukia, it will be difficult because the school was amalgamated on 14th of July, right? So before that, if you have to show, only that issue is sufficient. Otherwise, both of you are not qualified. You do not have BA degree. Take back this. When, tell us, give us a date.
Shortly that may be given.
लिखा है ना।
Next week.
For proper education of this case. The district elementary education officer in Chukia. Be imputed as party respondent number 5. Mr. Smdc standing counsel in Department of School Education and under declaring. On the next date fixed.
27.
The district elementary education officer in Chukia shall apprise the court since when the petitioner Mina Kanto Borgohai, headmaster of Sapakwa Town ME School,
School inspector of
with dice code 181404 16202, received the graduate scale of pay
inspector.
What was his scale of pay on 13/07/2017 prior to the amalgamation of said ME school with Sapakwa Town High School. High School 181404 Next. On the said date, the inspector of schools in Chukia shall apprise the court as to when the respondent number 4, Lal Bahadur Devi, assistant teacher of Sapakwa Town High School, received the graduate scale of pay. What was his scale of pay on 13/07/2017 prior to the amalgamation of Sapakwa Town ME School with Sapakwa Town High School?
Lal Bahadur Devi.
Copy of these orders. Oh, list on list. Mr. Sisti? Yes, sir. By 29th? Yes, sir. Copy of this order to Mr. Sisti. Tomorrow.
My lord, I need to mention item 16, my lord. This is urgency is there, my lord. 2020 petitioner was given in charge of the headmaster because of senior most. That amalgamated ME school teacher entertaining his objection, he was given. After that, the petition, it was fixed on for the admission hearing on 16/9/22. 8 dates, that was nothing. And there is no instruction to BTC. But kindly see, my lord, 16/9/2022 order. Admission stage it was. Then, my lord, kindly see 14/12/22 order. So matter is very simple. Whether who is entitled to. But only thing. 14/12/22. So why it is not inquiry is made on regular basis? Why they are allowed to entertain this? Because my humble submission is that he is not entitled because of transfer. He is transferred several times and lost his seniority. And he is not also a headmaster of that ME school, so that he could get the assistant headmaster of the high school.
You are Krishna, you are Pran, so you are everyone.
Lordship, that is the whole difficulty.
So he will be retired this year, I think. Oh,
No, not retired.
2020. So
Any affidavit filed by the director?
yes.
Pleading is complete, Lordship. Let it be on a hearing shortly.
Rejoin the affidavit, my lord, this director has said
Why the director has filed an affidavit?
No, it is BTC.
BTC.
Again, the provincial council.
The director of education has filed.
Yes,
Okay, that's it. Let us see what is there.
Regarding that seniority dispute. Instruction was short. Respondent number 5 has not filed.
My lord, may I please?
Respondent number 5 has not filed. They will submit orally, I think, from rule.
Now, Subrata Chakraborty has filed any affidavit?
Yes, Lordship. I filed it.
In his affidavit is admitted that on request he transferred was done.
I am on a different
Page
point.
43. So my
To be truthful does not mean that I am surrendering my case. He has not even completed 10 years. That apart, his appointment was in Fanchap.
10 years completed. 13 January I am regularized and 2030. All criteria is met. DA, everything is met. In page 46 of affidavit of position,
If Fanchar Pursucha's appointment is to be taken for seniority, my lord, there will be affable doomsday.
4 schools he is to reach that school. 4 schools he get transferred on request, and it's evident in page 46 of affidavit of position. Look, one thing I want to point out, your lordships, additional reason that affidavit.
We'll have it on 23rd.
23rd, already.
Item 19 on payment of salary. One time, so next week any date not.